I had a talk with my learned friend also. They have agreed. Lord, can a date be fixed on 14th?
Okay. No mention sleep.
Your Lordship.
No mention sleep. Anyway, item 14,
14, yes.
orders.
Orders, my lord.
You have 40?
I am for the, my lord, Bornelli Chetia, the respondent in the IE.
Okay. I think it's opposite party number 1.
Yes.
On request made by Shraddha and senior counsel for the opposite party number 1. This the matter on 14.
14th, my lord. In the meantime, interim order, my lord, may continue.
Interim order passed in the writ petition.
Main petition, my lord, WPC.
In the main writ petition to continue to the next section.
Obliged.
May it please, my lord. My lord, I pray for listing of an unlisted matter, my lord. And for-
Today?
Today, my lord.
Why?
My lord, petitioner has applied for a particular post. She is already working, my lord, but the college is not giving NOC for interview is scheduled to be held on Monday, my lord.
Then we'll take up tomorrow.
Tomorrow. Okay.
May I please? I beg to mention for listing of a matter on Monday. Matter is about, my lord, evaluation of HSLC answer statement. Less mark is given. Correct answer, no mark given. So matter
Why
last listed-
Monday? What is the urgency there? We have it on 16th.
60th. And
May it please your lordship. Lordship, I beg to mention one matter for listing tomorrow, lordship.
Why?
Lordship, in this matter, your lordship already heard this matter, that I have implemented another petitioner and the respondent filed one affidavit also, lordship. Additional affidavit they have filed yesterday. So tomorrow, lordship, for final adjudication, lord. Admission, pleadings complete,
Tomorrow there will be some difficulty.
lordship, then. As your lordship already heard to.
Is it a parted matter?
No, lordship, no,
Then we can have it on Monday.
lordship. Obliged.
My lord, may it please the lordship, my lord, item 19 of today's list, my lord. It's a hearing matter.
Hmm.
I'm yet to file my affidavit and a stand for vetting, my lord, has not reached. I have taken the consent of the petitioner. My lord. I am for the University Grants Commission.
How much time?
My lord, can it be 4 weeks, my lord?
Mr. A. Jamal, understanding council UGC submits that he has sent the affidavit for vetting. And prays for 4 weeks time to file contract.
Obliged, my lord.
Praise allowed. Please after 4 weeks.
May I please, your lordship. I beg to mention for listing of WPC 1200/23, your lordship, on 17th, your lordship.
Why 17th?
Any day, your lordship, on 21st or 22nd.
23rd. 23rd.
23rd, 22nd, your lordship. Obliged.
May I please your lordship? May I
Yes.
please your lordship?
Yes.
Lordship, I beg to mention item number 2, lordship.
Hmm.
I'm praying for HOD matter for 4 weeks, lordship.
You are Saharia.
Yes, lordship.
On request made by MSP Saharia, learning council.
Who eat along with three also,
Three
the
lots.
three then
Yeah.
different council of it.
The consent, lordship.
What's your date maybe?
This is the matter on, you want a date fix?
Lordship, after 4 weeks.
Okay. 15th September.
Alright.
Lord, I beg to mention a contempt matter, my lord, which has not been listed for more than 1 year, my lord. So on 22 or 23rd, my lord.
Okay.
22. my lord.
Your lordship, similar prayer for listing of contempt petition, your lordship. On
28,
21.
28.
May please your lordship. Lordship for listing of contempt matter, lordship. Because on the last occasion, it was instructed for.
28.
Obliged, lordship.
I am praying for an urgent motion listing tomorrow. This is regarding the selection list, which has come out on the 4th to the MBBS first year course. This petitioner has challenged the list. There is some illegality in it, and the urgency, as the lordship knows, the admission process is going on. Before further vested rights are created, lordship will kindly take it up tomorrow for motion.
Yeah.
May I please, lord?
I'm listing for 28, on 28. I'm listing this case on 28.
May I please, lord? Therefore, listing lordship, meta regarding promotional meta lordship. Last
30.
May please, your lordship. Your lordship, I beg to mention for listing of a contempt matter, your lordship.
30.
Deeply obliged.
May please, your lordship, I beg to mention listing of WBC number 2345 on Monday
Why?
for hearing. It was last listed on 6/9 of 2022 for orders.
17.
Okay, lordship, obliged.
May I please, your lordship, I beg to mention two writ petition lordship for listing
28.
obliged.
May I please, your lordship, my lord, I beg to mention a very old pending matter of 2015, my lord, as in the admission column on next week, any date, my lord.
17.
Obliged, madam.
Item 1 of daily list, motion.
So the state was to file an affidavit as paid for by the learned advocate general. my lord.
Yes, who appears? State.
Lordship, I am for respondent number 3, the National Medical Commission. I think
Matter may pass over for the timing, lordship. The advocate general is just on his way, lordship.
No, he said he's going to file an additional.
Yes, lordship, the affidavit is with us only, lordship.
Ma'am, we are filing it after some time, lordship, may take up that matter after. I will give a copy to your lordship also. And then
Have you filed it?
we are filing it now, that's why I'm paying my lordship, may take up after some time.
If you're filing it now, what's the point of filing? If there's some defect in the affidavit?
No, there cannot be, my lord. I have personally, my lord, looked into the annexes. Well, the AG is coming, my lord, so after some time, my lord.
Let it come on record. Let your affidavit come on record. We'll have it on Monday.
Monday.
So, Ganguly Learned Counsel.
Monday.
Mr. V. Gogol, and it's. You are the standing counsel.
My lord, health department.
Health Department submits that they are filing the additional affidavit within the course of the day. So accordingly, list is met on 40.
Obliged.
For admissions. For
Yes, Eka?
Not.
My matter is on Monday, lordship.
Monday.
Lordship.
We'll let the affidavit come on record.
Yes, put it on Tuesday because Monday, lordship. Oh, Tuesday. Okay, let it be on Monday. Highly approve.
May I please, your lordship. So the brief facts of the case is that, lordship, an advertisement was issued in the year 1991. 3/9/1991. That advertisement, lordship, will find at page 29A. Type copy is 29. Original copy is 29A. I have annexed the relevant portion of the advertisement, lordship. This was issued on 3rd of September 1991 for filling up the post of assistant teacher in upper primary school. Scale of pay is also given. The bottom line, lordship. We are concerned, lordship, kindly come to the page 29A. We are concerned with assistant teacher middle schools.
Where is that?
Page annexure 1, page 29A.
Serial number 3.
Serial number 3. Left hand side, lordship.
Oh.
Assistant teacher middle schools.
Oh.
Probable vacancies. Then minimum qualification. Higher secondary 2 years of equivalent. This much. Now pursuant to this advertisement, lordship, the respondent authority issued a notice. That notice, lordship, will find at annexure 2, page 30A.
30.
30. By this notice,
they have given the information regarding the date of interview. The interview for selection of teachers for ME school under Bongaigaon subdivision will be held from 5th of August 1993 in Railway Higher Secondary School, Bongaigaon. The candidates are requested to collect their roll numbers from the office of the District Elementary Education Officer and Deputy Inspector of Schools, Bongaigaon. Now, pursuant to this notice, the petitioners appeared before the interview board, subdivisional level advisory board. And finally, select list prepared, Lordship. That select list, Lordship, will find from page 31. This was issued on 16th of February 1994. The original copy, Annexure 3, page 31. 31I.
31.
Original copy.
Page.
Dio Bongaigaon, please find here the original copy, Lordship. I have given also the type copy also.
Yeah.
This select list published on 16th of February 1994. Please find, Lordship, got it?
Yes.
Please find here with a list of original candidates for appointment of assistant teacher who were duly selected by Elementary Advisory Board, North Salmara, and appoint them as assistant teacher for the advertised post of assistant teacher already sanctioned by the government in needy school. Now, Lordship will find this select list. The name of the petitioners, there are 3 petitioners. Their names, they have been selected and their name figured at. So for the petitioner number 1 is concerned, his name is figured at serial number 249, page 49, Lordship. Page 49. Serial number 249, Girinder Chandranath.
Petitioner 1.
Petitioner number 1.
Ah.
So for the petitioner number 2, his name figured at serial number 155, page 42. Page 42, 155. Name is Lordship Phuleshwar Nath, 155. And the petitioner number 3, his name figured at serial number 53. That Lordship will find at page 35. 53, Ali Ahmed. And thereafter, Lordship,
Serial number.
serial number 53, Ali Ahmed, page 35, the original list. I have given type copy also, but this is the original list. Photocopy of the original select list.
South.
Yes,
Boitamari.
South Boitamari MB school. All of them have been appointed in this particular school, South Boitamari MB school. Now, after this select list, they have been issued the appointment order. Appointment order issued on 28th of February 1994. Annexure 4, page 52. Annexure 4, 5, 6. These are the appointment order in favor of the petitioners. May I read the Lordship, the content of the appointment order, Lordship? This is relevant subsequent, Lordship. Annexure 4, page 52. As per approval of advisory board and subject to discharge without notice and reason thereof, Sri Girinder Chandranath, HSLC passed, son of Harakuma so and so. Local candidate is hereby appointed against the newly created post for assistant teacher of middle school and allotted post to South Boitamari MB school in the scale of pay 1185 to 2395 per month, plus other allowances as admissible under government rules. The post was originally created and allotted by government order number so and so 1991, and DE, that is Director of Elementary Assam, so and so dated number Date is 15/5/1993. This is in respect of petition number 1, annexure 5, 6. These are appointment order in respect of the petition number 2 and 3. Content of the letter is same, lordship, appointment order. Date is also same, 28th of February 1994. So thereafter, the petitioners join in the respective schools. I've also annexed the joining report. It starts from annexure 7, 8, and 9. From page 55. As per the reference cited above, I have joined so and so on 18th of March 1994. Thereafter, lordship, they have received salaries up to May 1994. Initially, they were appointed against a regular vacant post and also given time scale of pay as per the advertisement of 1991, and they received salary up to May 1994. Now, for some period, they are not paid salary. Then they approached this honorable court in 1995 itself. Annexure 10, page 58, serial number 1. It is the petitioner number 1. And these are the also similarly situated candidates. But I am concerned with the serial number 1. In 1995, for non-payment of salary, he approached this honorable court, and ultimately this case was disposed of, page 59, by order dated 25th of October 1995. Small order, lordship, may I read, lordship? In this case, notice of motion was issued on page 59, 25th of 10, 1995, date of order. In this case, notice of motion was issued on 27/9/95, and it relates to non-payment of salary of the teachers. But no instruction has been received as submitted by Sri B. Chaudhary, learned additional senior government advocate. Further, this matter is covered by judgment dated 3/4/95, passed in civil rule number 1381, 1995 and others. Accordingly, after hearing Sri Osmani, learned counsel for the petitioners, and Sri B. Chaudhary, learned advocate, additional senior government advocate for the respondent, this application is disposed of with the direction that the respondent number 4, that is the district elementary education officer, North Salmara at Bongaigaon, shall make an inquiry into the matter, and if the claims made by the petitioners are found to be correct, they shall be paid their salary in accordance with law and rules within a period of 2 months from the date of receipt of the order. Petitioner shall file this advocate so and so. Now, similarly, the petitioner number 2 and 3 also, they also filed a petition in the year 1996, that is annexure 11, page 60. So for the petition number 2 and 3, their serial number, lodge will find at page 61, serial number 42 and 43, page 61. 42 is the petitioner number 3, and 43 is the petitioner number 2. And this case was also disposed of in a similar line by order dated 20th of March 1996, page 62. Penalty paragraph, page 63, on hearing the counsel for parties, I dispose of this petition with a direction to the respondent number 4 DO to make an inquiry regarding the averments made in the writ petition. And on an inquiry, if it is found that averments made in the petition, and an inquiry if it is found that the averments made in the petition are correct, if they have been actually working as averred, and if they have not been paid their salary from May 1994, they shall pay their salary. So thereafter, lordship, in compliance of this honorable court's direction, communications were made internally within the department to release the salary. The first annexure, the letter of 6th of June 1995, lodged find at page 64, annexure 12. The DO concerned written this letter to the treasury officer for payment of salary to the appointed teachers, Lordship. With reference to the subject cited above, I have the honor to state that as per the Honorable Guwahati High Court's orders, I request you kindly to take necessary action for payment of newly appointed teachers of 1993 and 94. So ultimately, Lordship, they are not being paid any salary. Now, regarding this issue of non-payment of salary and regularization of teacher service of the teachers who were appointed during the period 1991 to 2001, this matter came up before the division bench. And ultimately, the respondent authority, in compliance of the order of a division bench of 30th April 2009, they issued an office memorandum that Lordship will find at Annex 14, page 66. Is guidelines for functioning of the screening committee constituted for the purpose of screening the illegally, irregularly appointed teachers working in lower primary and upper primary school. The first paragraph is relatively relevant. The issue of irregularly and illegally appointed teachers in lower primary and upper primary schools since 1991 to 2001 has drawn the attention of the government for quite some time past. Over 3,000 to 4,000 of such teachers have claimed to be working in lower primary and upper primary schools of the different districts of the state since their appointment during the period 1991 to 2001. There were about 6,000 High Court cases arising mainly from non-regularization of services and non-payment of salaries of these teachers, while issuing directions to the state respondents in the order dated 30th April 2009, passed in WBC number 1048 of 2004, the division bench of Honorable High Court has made observations within inverted commas. The present statements has continued for a considerable period of time as no decision is forthcoming, leading to multiple litigations and consequential hardships. We may also usefully recollect that on each and every occasion in the past, when the issue had come for consideration, the court had been told that the cabinet is in the process of taking its decision in the matter, and a resolution can be expected shortly. But such decision has not seen in the light of this, not seen the light of the day till date. So ultimately, Lordship, they have constituted screening committee to find out the teachers who were appointed during this period 1991 to 2001 for regularization and payment of salary. And pursuant to this notification office memorandum, the government issued advertisement, that is Annexure 15, page 69. By this advertisement, they invited the teachers who were appointed during this period to submit the information and documents, Lordship, with the application like Lordship. Paragraph 2, it is quoted, Lordship. And the petitioners also responded to this advertisement. They have submitted their particulars. Now, ultimately, the government taken a decision to accommodate the service of such teachers. That order also will find at page 73, 30th of January 2021. I am aggrieved, although I have accepted this order, but there are some condition is imposed. So let me read out the content of this appointment order, Lordship, accommodation order. This was issued on 30th of January 2021. In exercise of power conferred upon the Director of Elementary Education Assam, filed letter number so and so, and in pursuance of the government approval, communicated dated 21/1/2021, and subject to satisfactory police verification, report, and production of physical fitness certificate from concerned Joint Director of Health Services, the following candidate is hereby accommodated as tutor. This is relevant, Lordship. We are aggrieved by this term, Lordship. Accommodated as tutor in LP, lower primary, and UP, upper primary school on purely temporary basis in the fixed pay of rupees 10,800 as per the Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017. And effect is given with effect from 1/11/2020. Now, our grievance is that, Lordship, although the authority accommodated the service of the petitioners as tutor, but this has been done under the Provincialization Act of 2017. The aim and object of this 2017 Act is meant for those teachers who are serving in a Fensar schools, and authority has taken steps to provincialize those Fensar schools. But here, Lordship, the case of the petitioner is that they have been appointed pursuant to a valid selection process that by followed under the rules of 1977 law. The advertisement of 1991, thereafter they appeared before the sub-divisional advisory board, then select list published, then appointment order issued, then time scale of pay is also given to them. Now here, Lordship, the authority has accommodated the service of the teachers in a fixed pay as tutor. This part, we are aggrieved by this part. They cannot do so. And in this respect, Lordship, they have filed affidavit also. And in the affidavit, they have admitted everything, Lordship. Only says these teachers have been accommodated as tutor pursuant to government decision. It will also kindly take up the affidavit filed by the respondent authority. On page 79. Paragraph number 6, 7. They have not offered any comment. Paragraph number 5 also, no comment. Only the paragraph number 8, it says, the second paragraph of paragraph 8, page 81. The name of petitioners were approved by the government for accommodation as tutor. And they have been issued appointment letter as tutor from the office of the answering deponent with prospective effect. No reason is assigned, Lordship, as to why their services have been accommodated under the Provincialization Act of 2017. Now, this Act of 2017 is itself a stranger to the service of the petitioners because they have been appointed under a rules of 1977, Assam Elementary Provincialization of Service Rules 1977. Their procedure is laid down, qualification is laid down, how to advertise the page, how to select, everything is there. And after following the entire procedure, the petitioners have been appointed. I filed reply, Lordship, to this affidavit. In my reply, Lordship, kindly take up the reply filed by the petitioners. Page 91. It starts from page 90. Page 91, paragraph 3. That in regard to the statements made in para 8 of the affidavit in opposition, deponent begs to state that the decision of the state respondents to accommodate the service of the petitioners as tutors on purely temporary basis in the fixed pay of rupees 10,800 as per Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017 by order dated 31/2021 is absolutely arbitrary and irrational. That all the petitioners are assistant teachers who are serving at South Baitamari MB School under Bongaigaon district, and they were appointed during the year 1994. Petitioners contended that the selection process was initiated by the advertisement dated 3/9/91 for filling up so-and-so post in LP UP school in the state of Assam by following the provision of Assam Elementary Education Provincialization Rules 1977, as amended from time to time. Pursuant to such employment notice, all the petitioners participated in the recruitment process and appeared in the interview before the Subdivisional Advisory Board for Elementary Schools Bongaigaon on 5th of August 1993. Thereafter, a subdivision-wise select list prepared and the petitioners were selected for appointment as assistant teachers of upper primary schools by the North Salmara Subdivisional Advisory Board under Bongaigaon district. The select list dated 16 to 1994 and same was signed by the Honorable Minister cum Chairman of Subdivisional Advisory Board, North Salmara, where the name of the petitioners figured at serial number 249, 155, 53. Already I have shown lots, annexer 1, 2, 3 of respective. The petitioners were appointed as assistant teacher in South Baitamari MB School by D.O. Bongaigaon on 28 to 1994. Accordingly, they have joined in service with effect from 18 to 1994 in the said school. The petitioners were appointed against regular scale of pay as per the advertisement dated 3/9/1991, that is rupees 1185 to 2395. Initially, petitioners were paid their salary with effect from March 94 to May 94, thereafter stopped their salary. Paragraph 6, the Assam Elementary Education Provincialization Service Rules, Teachers and Reorganization of Educational Institution Act 2017 came into force to provincialize the service of the teachers of the Vansar educational institutions and also to reorganize and streamline the educational institutions up to degree level in the state of Assam, and same is not applicable in respect of already provincial school by the government. That fixing educational qualification as per right of children to free and compulsory education act NCT under the Act of 2017 for teachers and tutors is against the qualification prescribed by the NCT notification dated 23/8/2010, wherein it was mentioned that the teachers who were appointed prior to 3/9/2001 need not acquire the minimum qualification as specified in Part 1 of the notification dated 23/8/2010. Admittedly, the petitioners were appointed in their respective schools prior to 2001 in 1995, and they were eligible to be appointed as teachers being qualified as per Rules 1977 at the relevant point of time. The Act of 2017 cannot operate retrospectively. Therefore, the qualification prescribed under the Act of 17 is also arbitrary. I have annexed the notification of 23/8/2010. Now, Lordship, the Act of 2017, it defined the term tutor. The teachers who are serving in a school but not having the requisite qualification prescribed under the RT Act, those are become the tutors. But they have followed, the RT Act followed the qualification prescribed by the NCT regulation, that I have annexed that regulation, the qualification, Lordship, after 2010. Lordship, may kindly come to Annexure 19, page 97. Qualification for class 1 to 4, this is for lower primary, and for class 5 to 8, it is for upper primary. In exercise of the powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009, and in pursuance of the notification dated so and so issued by the Department of School Education, Literacy, Ministry of Human Resource Development, Government of India, National Council for teacher education hereby lays down the following minimum qualification for a person to be eligible for appointment as teacher from class 1 to 8 in a school referred to in the clause under section 2 of the Right of Children to Free and Compulsory Education of 2009. Now the qualification also will find at page 98. This qualification followed after 2010, after the RTI came into force. Degree with 50% marks and DLA.
Where is that?
Page 98. Class 5 to 8, BA, BSc, 2-year diploma in elementary education, or BA, BSc with at least 50% marks, or 1-year bachelor in education. Now, this is the qualification prescribed under the 2000 Act, which is followed under 2017 Act. Now, the teachers who are appointed prior to this 2010 notification or 2001, for those teachers, the qualification prescribed under the RT Act, which is followed in the Provincial Act of 2017, those teachers are not required to possess this qualification. That the regulation itself says, Lords. Lords, now kindly come to page 99. Clause 4. Clause 4, page 99.
Do you have a better copy?
Let's see. I'm also having one copy. Let's see. Teachers appointed, clause 4, teacher appointed before the date of this notification. The date of this notification is 23rd of August 2010. The following categories of teachers appointed for class 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. As already I have read out, Lordship, the qualification for class 5 to class 8, degree with 50% mark, and DLED degree or BEd degree, Lordship. But in spite of this also, Lordship, they have whimsically, Lordship, incorporated this qualification, and since these teachers, Lordship, they have not possessed this qualification, 50% marks as well as DLED degree. Their services is now accommodated as tutor, Lordship. That they cannot do so, Lordship. Because these teachers were appointed under the rules, Lordship. Now coming to the second one, Lordship, page annexure 20, page 100. The authority now prescribe the term and condition of the tutor, Lordship. Annexure 20, page 100. In exercise of powers conferred under subsection 3 and 4 of section 8 of Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institution Act 2017, the Governor of Assam is hereby pleased to notify the following scope of works, terms and condition of services in respect of the tutors whose services have been provincialized under this act. The post of tutor shall be a separate cadre. It shall not be with the cadre of teachers, as and when a tutor whose services have been provincialized under section 4 of the aforesaid act acquires the requisite qualification, the post shall be upgraded to the post of teacher and shall be in cadre in respective cadre of a teacher. Second one, the clause 2, Lordship, the tutor shall continue to perform their duties as per the earlier responsibilities prior to provincialization. To illustrate, if the services of a science graduate teacher is provincialized as tutor, he or she shall have to teach science subject as was done earlier in the school prior to the provincialization of his service or her services. A tutor shall be assigned duties at par with other teachers as was assigned prior to provincialization without any disparity with other teachers. The tutor may be engaged for examination duties. So the duties and responsibilities performed by the teachers it is at par. These teachers also performing the same duties with same responsibilities. But in spite of Lordship performing the same duties and responsibilities, the service of the petitioners, they have been accommodated as a tutor in a fixed pay, although they have been appointed in 1994 against a permanent sanctioned vacant post, Lordship, and time scale of pay is also given. So we are only aggrieved by this part of condition of the accommodation order of 30th January 2021. Because their initial appointment were given against a substantive post, against a permanent post. And there was no such any condition. That is why already I have read out the appointment order of the petitioner's lordship. There is no such condition that subsequently their term of appointment will be changed. Now the settled law says, lordship, once the appointment is given, again, it's a substantive post that you cannot change later on, lordship. The term of appointment cannot be changed. And the respondent also, they have not filed any reply. And in the affidavit already I have shown, they have admitted everything. But no reason is assigned why this petitioner service has been accommodated as tutor, lordship. Also, I am relying on the decision, lordship, of the affairs court, lordship. I may be allowed to furnish copy. (2021) 10 SCC, page 116. Here also a batch of teachers, they filed this appeal, lordship. Their term of appointment will change. I am relying from paragraph 37. Paragraph 37 onward.
Yes.
From the narration of facts as being referred to supra, it clearly manifests that the appellants were appointed after going through the process of selection as contemplated under Part 6 of the Act of 1973, which indeed was a appointment on substantive. Paragraph 37. I'm sorry, Lordship. From the narration of facts as being referred to supra, it clearly manifests that the appellants were appointed after going through the process of selection as contemplated under Part 6 of the Act of 1973, which indeed was an appointment on substantive basis. And since the appellants were not in an equal bargaining position and were in the need of employment when the offer of appointment was made, left with no option but to accept such arbitrary conditions incorporated. Similar, Lordship, the petitioner also ultimately they have no bargaining authority. Ultimately, they have accepted this accommodation letter of 30th of January 2021. Treating to be contractual for a limited period till recorded their protest while joining, but no heed was paid. When they were allowed to continue by extending their services, they remain under a bona fide belief that as their appointment is being substantive in character, they will be made permanent or confirmed immediately after the permanent posts are sanctioned in the Department of Pharmaceutical Sciences, but to their dismay, after an advertisement at the 29th August 2011 came to be notified by the respondent, Central University, no option was left with them but to approach the High Court by filing of a writ petition. If we look at the scheme of the Act of 2009, which came into force from 15 January 2009, HNB Gharwal University is converted to a Central University under the Act 2009. And it took over the assets and liabilities of the university. This is not relevant, Lordship. According to the fact Lordship reason cited regarding the establishment of universities, then selection committee. From paragraph 42, Lordship. The submissions of the learned counsel for the respondents that the appellants have accepted the terms and conditions contained in the letter of appointment deserves rejection for the reason that it is not open for a person appointed in public employment to ordinarily choose the terms and conditions of which he is required to serve. It goes without saying that employer is always in a dominating position and it is open to the employer to dictate the terms of employment. The employee who is at the receiving end can hardly complain of arbitrariness in terms and conditions of employment. This court can take judicial notice of the fact that if an employee takes initiation and questioning the terms and conditions of employment, that would cost his or her job itself. The bargaining power is vested with the employer itself, and the employee is left with no option but to accept the conditions dictated by the authority. If that being the reason, it is open for the employee to challenge the conditions if it is not being in conformity with the statutory requirement under the law. And he is not stopped from questioning at a stage where he finds himself aggrieved. In the instant case, they lodged the protest petition and brought their grievance to the notice of the respondent, but were unable to question except to pray the Almighty to consider the grievance sympathetically. Now, paragraph 45 to 48 is relevant in my case, Lodge. The term substantive appointment is not so defined in the legal dictionary, but has been referred in the service jurisprudence by the recruiting authority while framing rules. Under Article 309 of the Constitution, and what being termed as substantive appointment can be gathered from UP Sales Tax Officers, Grade 3 Service Rules 1983. The relevant extract is under. Substantive appointment means an appointment not being an ad hoc appointment on a post in the cadre of the service made after selection in accordance with the rules. If there are no rules in accordance with the procedure prescribed from time being by executive instructions issued by the government. The definition of substantive appointment can further be noticed under Rajasthan Administrative Service Rules 1954 as under. Substantive appointment means an appointment made under the provision of these rules to a substantive vacancy after due selection by any methods of recruitment prescribed under these rules and includes an appointment on probation or as a probationer followed by confirmation on the completion of the probationary period. Almost similar nature of rule is available in the services where the recruiting authority has defined what is held as substantive appointment under the recruitment rules framed under Article 309 of the Constitution. And this clearly defines that an appointment made in accordance with the scheme of rules are held to be substantive appointment. Adverting to the facts of the case, undisputedly, the appellants were appointed pursuant to an advertisement dated 4th February 2004 and 19th May 2006, held for regular selection, and after going through the process of selection as being provided under Chapter 6 of the 1970 Act, and on the recommendations being made by the Statutory Selection Committee constituted under Section 31(1) and 4 of the Act, approved by the Executive Council, which is a statutory authority. Appointments were made in the year 2004 and 2007. Now, in our considered view, once the appellants have gone through, this is the case of the petitioner lordship. In our considered view, once the appellants have gone through the process of selection provided under the scheme of the Act of 1973, regardless of the fact whether the post is temporary or permanent in nature, at least their appointment is substantive in character and could be made permanent as and when the post is permanently sanctioned by the competent authority. Now, Lordship may kindly take up the old code because in the new education manual, the rules which was prevalent at the time of appointment. I'm reading from this book, Lordship. The name of the rule is same. This was the edition of 2000, Lordship. This rule is also under 309.
What is the name of the rule?
Assam Elementary Education. Sorry, madam. Assam Elementary Education Provincialization Service Rules 1977. I'm holding a very old book, Lordship. It may not be available, Lordship. These are the amended version of the 1977 Act. From time to time, Lordship, these rules 1977 have been amended.
Assam Elementary Education.
Education Provincialization Rules 1977. Under 309, this rule has been framed. Here it prescribed the method of recruitment, then method of qualification, then regarding constitution of the selection committee, everything, and qualification also. So my case is that, Lordship, after following this prescribed procedure, we have been appointed against the substantive post, against the permanent post. They have not denied it. But without any rhyme or reason, Lordship, suddenly under 2017 Act, the service condition of the petitioners have been changed. Initially, we have drawn salary at a regular scale of pay, as I have shown those appointment order itself shows. But in 2021, in a fixed pay of 10,800, the service of the petitioner have been absorbed. We are agreed by that condition only. In service jurisprudence, there is no any term for accommodation. We are not asking for any provincialization of service. We are recruited under the rules. But abruptly they have changed and then they impose these conditions. So this post is also personalized post. They cannot claim any service, past service benefits. And instead of time scale of pay, they have been paid a fixed pay of rupees 10,800. And that too also, in the guise of they say that these teachers have no qualification, that is why their services are provincialized as tutor. But the rules, regulation of 2010 of NCT, it clearly says the teachers who were appointed prior to 2010, for those teachers, the qualification prescribed under the RTI is not required. At the relevant point of time when this advertisement was issued, the only qualification is HSLC, higher secondary pass. The advertisement itself, Lordship, shows, Lordship. Qualification is HLG, 10+2. That is why, Lordship, under the rule settled laws and the rules, Lordship, the condition which is imposed in the impugn order, although we have accepted, but it is arbitrary, Lordship. And they have not denied it, although they have filed affidavit admitting everything, Lord. So let the authority, Lordship, give a direction, Lordship, to examine this issue under these settled laws, Lordship, and take a, Lordship, a call, Lordship, final, they should come to a final conclusion whether this condition is applicable in respect of the petitioners or not, Lordship. But the rules and the law, it clearly says they cannot impose these conditions, at least in respect of the petitioners, since they have been appointed pursuant to a valid selection process, and they have not denied it, Lord.
Yes.
That's all.
First issue is how you brought them under the 2017.
Malad, this was basically based on a decision of the government
Where,
policy.
where have you stated that in your affidavit?
My lord, it is the admitted case of the petitioner itself, case paragraph 14.
Paragraph 40 or
Paragraph 14 of the petition.
14?
14. 14 and 15, may I read it, my lord? This is very relevant.
Yes.
The petitioner humbly begs to state that pursuant to the report of the divisional screening committee, so the divisional screening committee was constituted pursuant to the direction of this honorable court in a division bench. Decision was taken by the government to regularize the service of the teacher who fall under the category. In the meantime, a discussion was held between the honorable minister and teachers association in respect of the aforesaid 8470 numbers of illegally appointed teachers on 7/9/2018 to resolve the issue. In the meantime, the fate of third category of teachers numbering 8470 came up for consideration before the honorable court in a batch of repetition, and this honorable court, after hearing the parties, was prima facie satisfied that since this category of teachers are working in spite of not getting salary, they are entitled for some interim relief. Accordingly, so and so order dated passed in so and so and other connected was pleased to direct the state respondents to release 1 month salary to the petitioner, therein who are come under the third category of petitioner teacher. The petitioner crave leave of this honorable court to produce the copy of the order dated at the time of hearing of the case. The petitioner begs to state that they have been working as assistant teacher in their respective school from of date of joining without any break in service. However, they have been deprived from their legitimate salary, though services have been extracted from them by the respondent. As already has been stated herein above, the issue of regularization in irregular had already been dealt with by this honorable court, and this honorable court by the order dated made it clear it will be open for the state to frame a policy in accordance with the law for eventful accommodation of the illegal appointed teacher who have been identified on the field of verification to be done working. In compliance of the said direction, the screening committee was constituted, and the screening committee submitted its report verifying that 8470 numbers of teachers were not recommended, but they have been working continuously, including the petitioner.
Where is this report?
Malad, the policy decision.
Screening committee report.
Malad, screening committee's report, we have not annexed it, Malad. But the petitioner, Malad.
See, petitioner's issue is this.
Yes, then they
I
cannot-
don't know what happened in the division bench.
Malad.
Advertisement. Prescribing scale of pay. They participated in the advertisement. I mean, in the recruitment process. They went through the whole process and they were selected. Correct? After selection, they were given the appointment orders. Now, the question of illegal or irregular appointment, where does it arise?
Malad, page 66 was the office memorandum pursuant to the decision of the division bench to examine the claims of all teachers who were illegally and irregularly appointed. And thereafter, page 69 is the advertisement. An advertisement was issued in the newspaper calling for application from all the candidates whose appointments are irregular and illegal. The petitioner admittedly participated in that process, meaning thereby, my lord, he also admits that his appointment is irregular or illegal.
No.
This, my lord, will find page 672. The petitioner was called for submitting his application for appearing in the verification process.
Yes.
And this is pursuant to page 69. May I read page 69, the advertisement?
Yes.
Government of Assam Education Department has constituted a screening committee to examine the claims of teachers who were, it should be irregularly, my lord. In typed, it is regularly written, but in the original advertisement, it is irregular. Page 71. Irregularly, illegally appointed and working continuously in the lower primary, upper primary school in the state since 1991 to 2001. Applications are invited from the persons who were appointed during the period 1991 to 2001 in different lower primary schools and are working without any break till date, but not getting salary since joined or only intermittently. So pursuant to the process which was undertaken to verify the claims of those teachers whose appointments prima facie was found to be irregular and illegal. And the petitioner participated in this process. Now he's stopped from claiming that his appointment is substantial. Now, my lord, after the process has been done, the committees have categorized the candidates in 3 categories. And among the 3 categories, my lord, the first category and the third category, the government has taken a policy decision to put an end to this and to accommodate them as a tutor in a fixed pay. And they have also accepted this appointment, the accommodation as a tutor. So, my lord, now the petitioner, when he has himself participated in the process which was initiated long back.
Now there are 3 categories, isn't
My
there?
lord.
First category, second category, third category.
Third category.
Now petitioners comes under which category?
Third category. And the third category was they were not
Who is
recommended.
that category? Is it in the screening committee report?
It would be in the screening committee. In fact, the petitioner admitted in his petition at paragraph 50.
Who is that report, the screening committee report?
That I'll have to produce.
You produce the report.
I'll produce
we'll
that.
see.
I'll produce that. In fact, your
What
lordship,
what date is it? The report of the screening committee.
I'll produce the report. My lord, if your lordship allows me, I'll file an additional affidavit bringing the background of the entire thing, my lord, in one writ petition of a
That's
similar
why
nature.
your affidavit, nothing is coming
Yes,
from your
I,
affidavit.
I,
Just one paragraph, paragraph 8 or what.
I've seen that.
It says that
And I cannot improve my case on the basis of what is there in the record. So the additional affidavit, my lord, I'll bring on record the entire backdrop of the case, my lord. In one writ petition, we have filed a detailed affidavit with regard to the cases of the similar nature. Because there were several of appointment since 1991 to 2001. And pursuant to a decision of this honorable court in a division bench, my lord, we constituted this committee, and this office memorandum was in compliance to the direction of the honorable court. Now, my lord, the one core issue will be, my lord, now the petitioner, when he has admittedly participated in a process which were initiated to verify illegal and irregular teacher, meaning thereby, my lord, he has accepted the claim that his appointment was irregular or illegal. Now he is stopped from making the claim that his appointment is substantial, so he cannot be reappointed. And the policy decision is not challenged in the writ petition. And it is not the case of the petitioner that he is unaware about the policy. My lord has read paragraph 15.
all this will flow out from the screening committee report.
Yes. I'll bring that screening committee
Would
report.
have been written on your part to have at least annexed that copy.
My lord, I am.
So my
It's
case
my
is
fault.
that the office memorandum pursuant to which this advertisement and screening committee is followed. They have not said anything about the teachers, that their service will be accommodated as tutor. It is only after the 2017 Act.
Let us see what the
And-
screening committee
yes,
report is. all
But
about.
then other also this, under this Act 2007, it is not at all applicable in respect of the petitioner. Because we have been appointed in the provincialized schools. That is the case.
But say they call it. After hearing the participant. This court deems it necessary that the respondent should file a detailed affidavit, giving the background of the whole case,
My lord.
as well as annexing a copy of the screening committee report. So. Is the matter after
3 weeks, my lord.
3 weeks.
Highly.
Obliged.
Five.
But in this case, before my lord, senior friend starts, my lord, I'll pray for an accommodation for the day, my lord. Doctor will take up this matter on Monday.
Monday, fixed many cases.
Or on Wednesday.
Tuesday, lordship. He's carrying the lordship because my part already
Tuesday is
finished.
15 hours.
Oh, then
Third K. Majumdar Learning Council
17 lordship.
on request made by Mr. D. Kaushik, the Standing Council, Elementary.
Well, last occasion also they've taken time. lordship.
17th.
High level.
6,
Maybe his lordship. Matter may be taken after some time because my learned friend M.R. Khandogar is busy with another matter.
Next Tuesday. Or Tuesday.
On request made on behalf of Mr. M.R. Khandagar, that council for petitioner. List of the volume.
7 and 8.
Look, we have just filed an affidavit in reply, my lord. Perhaps it has not come on record.
I have filed my reply affidavit on 2nd of March. And today the date is fixing today, my lord, and today he
She
is going
took
to
2 weeks to file
affidavit.
her affidavit in opposition. I only took 1 week, my lord. That also she is objecting.
Whatever it is,
Your lordship may fix it next week,
Next week, my lord, on Monday, my lord.
Monday,
Monday I fixed many
Tuesday,
cases.
then my lord, 16, my lord, 16 or 17, my lord.
17 will be better.
Mr. A.K. Barwa,
Take it.
the council for the petitioner, subjects that he has filed an affidavit in reply this morning. Stop. We still verify and place the same on it. Also heard MS Gyan, Leonard CGC
CGC.
for the respondents, 1, 2, 3. Is the matter again on?
17.
17 will be better. Herringly, it can be disposed of. No, interim protection may continue.
Interim order passed earlier to continue.
Obliged, deeply.
9.
Okay, item number 9, we need some account. We have to file an additional affidavit. We have filed earlier an affidavit, but that we'll have to recall that affidavit, because that order was subsequently cancelled, lordship. So we need to file another affidavit, lordship, in item number 9. And 9, 10, both the item, lordship, we need some accommodation. Yeah, I have already informed in the morning, lordship, the council for the petitioners, lordship.
You are appearing?
Yes, petitioner.
Your good name?
R. Chauhan.
R.
Chauhan.
Heard Mr. R. Chauhan, Leonard Council, appearing on behalf of Mr.
I. Chaudhary.
I. Chowdhury, Leonard Senior Counsel for the petitioner. On request made by SMT Krishna, Leonard Standing Council,
Secondary education.
Secondary Education.
Yeah. We need to file an additional affidavit in
much
item
time?
number 9, 2 weeks time.
2 weeks time is allowed to file an additional counter affidavit. This after 2 weeks.
Yeah. And so for 10 lawsuits also after 2 weeks. lawsuit.
Same order.
As, no, here I will not file additional, we have only filed an affidavit, but both the items should be come together. Lawsuit.
Then you just say heard Mr. So-and-so appearing on behalf of so-and-so. On request made by SMT Krishna, Leonard Council, Leonard Standing Council, Secondary Education, list of activities.
Lawsuit kindly make it 3 weeks. Lawsuit kindly lawsuit both the items 3 weeks. Lawsuit make kindly. Oblige it.
11.
No, it will be taken after some time because Eddie is appearing, madam. He's on this way, madam. Who? Advocate General is appearing this case, madam. He's on the way.
20, 21 and 22 of supplementary list admissions.
Where's the other side?
It may be for the time being, lordship, because the short matter regarding the NOC of
for opening the pharmacy course, Lordship.
Health department. Okay, after some time.
Lordship.
Eleven.
My lord, I'm challenging the order dated 19/6/2023, whereby, my lord, my service has been, my lord, rather, my lord, I have been relieved from the service on the ground that the agreement that was executed has expired on 30/11/2022. My lord, the petitioner was appointed under the, my lord, SSA after due selection, my lord, process, my lord, way back in the year 2022. As per, my lord, the condition of the, my lord, service regulation, which is applicable, my lord, to the employees under the SSA, an agreement is to be executed. And that is normally they make it for 11 months, and this has been renewed. Now, what happens, my lord, as, my lord, in the SSA, only three kind of, my lord, recruitment are there. Firstly, my lord, either they are, my lord, on deputation, the government officers. Secondly, additional interest, and third, my lord, contractual employees. There is no, my lord, regular employees as such, my lord. But their service condition is governed by a set of regulation of 2003. Now, in practice, what happens, my lord, notwithstanding, my lord, the completion of the term, the service are, my lord, continued, and on a, my lord, subsequent date, the agreement is executed from the retrospective date. My lord, that has been done, and by that process, my lord, I have been, my lord, in service last, my lord, 21 years. Now, my lord, here, sometime, my lord, on 4/5/2023, my lord, an FIR had been lodged. In fact, the inquiry was conducted through me, and I have submitted the report, and on the basis of an FIR has been lodged. My lord, there it has been found that the accountant, instead of, my lord, the sending the amount for the allocated to the schools, etc., she on her personal 3 accounts, she had diverted the amount to that, my lord. Though, my lord, there is no allegation against me, yet, my lord, I have been questioned initially, and thereafter, my lord, section 409 was added, and I was also arrested. But considering, my lord, my lord, less involvement in the offense, within 48 before expiry of 48 hours, I have been released, so I continued in service. Thereafter, they had issued a so cause notice, to which, my lord, I have also replied. Now, my lord, under the this regulation, if any, my lord, disciplinary proceeding is to be initiated, in that case, my lord, the provisions of the Assam, my lord, Services Discipline and Appeal Rules 1964, that will be applicable. Now, accordingly, they have proceeded with the issuance of the so cause notice. I have submitted the reply. Now, thereafter, my lord, it is the, my lord, they have to frame the charges, and then my proceeding should be, DP should be initiated, and my lord, things should go, my lord. But they, to make it a shortcut method, my lord, what they have, my lord, done, they have issued the order dated 19/6/2023. The lordship will find, my lord, is at page 52.
Which?
Page 52. Mohammed Giyas Ali, Finance and Accounts Officer, SSA, Dibrugarh, Assam, is hereby released from contractual service on account of his lapse of contract agreement on 30/11/2022. This order will come into effect immediately. My lord, though it was passed on, my lord, 19/6/2023, but till, my lord, 28/6/2023, it was, my lord, not even, my lord, received the office of the, my lord, DMC Dibrugarh. Until today, I have not received any, my lord, the physical copy of the, my lord, order. Now, my lord,
Are you still serving? No.
but I'm not in service, my lord, because I have not been allowed to join, my lord. But I have not handed over charge, my lord. Now, my lord, as because the so-called notices were issued, my lord, I had, my lord, apprehension that this service has been terminated on the ground of, my lord, my involvement in that particular, my lord, police case. And instead of, my lord, disciplinary proceeding, my lord, to make it a cut-short method, they have adopted that. Now they have filed an, my lord, affidavit in opposition. So they are, my lord, saying that no action has been taken as per my involvement, but then it is in, my lord, as because the, my lord, the agreement has expired on my lord, in the month of November 22. So therefore, my service has been released. Now, throughout Assam, all these employees are continuing. None of the persons, my lord, the agreements have been renewed. All have been, my lord, in service, but only I have been singled out for that, my lord. Now this regulation is concerned, my lord. Perhaps a copy is already there of the regulation, my lord. Now, Lordship, may I first come to, my lord, rule 3, my lord. At page 2, my lord.
Yes.
Rule 3, my lord, status of the service. All engagement to different services of the mission shall be either on additional charges, ex officio attachment, transfer, deputation, or on contract basis or limited period. So there is no, my lord, regular employee as such, my lord. Now, Lordship, may I come to, my lord, rule 6, my lord. It's a general conditions, my lord. Page 8.
Yes.
My lord, I'm taking a lot directly to, my lord, clause 6(o), my lord. All contractual employees will have to sign an agreement.
Yes.
Now, my lord, rule 7 says, my lord, reversion or discharge. A person holding a service in Assam on deputation attachment shall be liable to be reverted to his original service if he fails to render satisfactory service in the post held. So it is for the, my lord, employees who are on deputation and attachment. Now B concerns me, my lord, any person engaged on contractual service for a specified period under an agreement shall also be liable to be discharged, released from ASSAM if she has failed to discharge duties satisfactory and as per terms of the contract. So, my lord, it is only, my lord, while the service or the duties are, my lord, unsatisfactory, then this can be done. Now, rule 8 further, my lord, says continuation of employees on deputation attachment and further engagement of employees on contractual in mission service. After successful completion of the term or agreement or deputation, mission director will follow following procedure and arrange for continuation of employees on deputation, attachment, and further engagement of employees on contract in mission service. Executive Council, EC Executive Council will inform once in a year regarding deviation made, if any, from the prescribed process of continuation, number of category or employee who have been allowed to continue in mission service. Now, my lord, next page, the process that has been mentioned, my lord, in 8A, the process is there, my lord, process to be adopted on the right hand side. Now, category of post, my lord, serial number 19 is my post. So the process to be, my lord, process to be adopted for continuation or, my lord, for my lord, discontinuation, review and comments on the performance by, my lord, fourth, my lord, CAO for serial number 19. That is Chief Accounts Officer his review and comments to be placed before the executive council, and then a decision will be taken whether to continue or discontinue. But pending all this, these services are continued as I have told, my lord. In fact, I have also enclosed one of the annexure where to show after me, some of the person transferred from this place to the other place. Their agreements were also not renewed, my lord. And in fact, my lord, I have also stated in my reply that none of the employees in Assam, my lord, this agreement has been renewed for the year 2022-23, my lord. Now, after the writ petition being filed, my lord, the process was initiated by them. So far as Dibrugarh is concerned, to get the agreement executed among the parties. By now, perhaps they have done it. But so far as otherwise, prior to that, none of the employees' agreements have been renewed. So, here Lordship has seen the impugn order. It is simply said as because the term has expired on 22/11/2022, so it cannot be continued. Whereas from 22/11/22, I have till the date more than 10 months I have already worked and they have paid. The scale, etc., everything is paid. But only to make a cut short method of adopting the disciplinary proceeding, because there is a notification. The Lordship will find that notification. 29, my lord. SAVE has otherwise expressly provided, page 29. SAVE has otherwise expressly provided in service regulation and financial regulation of Assam Sarva Shiksha Abhijan Mission. It is hereby notified that the spirit of the rule and procedure as prescribed under Assam Service Discipline and Appeal Rules 1964 followed by Government of Assam for inquiry, departmental proceeding, award of punishment, appeal, etc. shall be followed by ASSAM as and when an inquiry or departmental proceeding are required to be conducted in respect of any employee, contractual or otherwise employee under ASSAM. It's a procedure will have to be adopted. So to cut short this method, they have adopted this method. Now your Lordship will, if they from the records, let them show this process as mentioned in Rule 8 has been adopted, and they have found my reason for discontinuation method. Rule 8, that review and comments that placed in before the executive council, and then they have taken a conscious decision that my service should not be discontinued. And the reasons among all, while all the employees are continuing, why I have been subject to only single out for the purpose of discontinuation of my service. That is my subject to what the record reveals and the submission made by the, I'll submit my reply.
Records are there? Records are there, Lordship. I do not want to disclose a lot of records because I do not want to make it public that he has been released with an order. Now the order is not having any stigma, but if I disclose everything, it will become stigmatic for him. The thing is that he was the final accounts and finance officer of this office, Lordship. And under his active involvement, 30 lakhs rupees was transferred into a accountant's account, showing to be school. The FIR is at page 32.
Of your
Yes. No, of the writ petition. We want to make it a simple, simply a case of discontinuation. The police case is going on. The FIR 3/5/2023, page 32. To the officer in charge, Dibrugarh Police Station, Dibrugarh FIR. With due respect, I would like to inform you that after scrutinizing the fund released to schools, etc., along with the bank transaction statements of our savings bank account number so and so, it has come to notice that some fund released to the schools persons concerned credited to bank account number so and so of Choki Dengi of Indian Bank, Dibrugarh Bank, which are not belong to the schools or the persons concerned for which the fund was released during April 2022 to March 2023. After verification of the aforementioned bank accounts numbers with the bank concerned, it has come to know that the bank holders of the aforesaid bank accounts were Dhoritri Gogoi Saikia, working as accountant at District Mission Office of the Samagra Shiksha Dibrugarh Tulsi Gaon. I therefore request you to consider this matter as urgent and necessary action. In terms of this FIR, this lady was arrested. She was the accountant and he was the senior officer, accounts and finance officer. He was also arrested, although he was saying that he was arrested on 10th and released on 12th. If Lordship, please come to page 34. This is their record. Here, notice under 50A was issued. Then Lordship will kindly see, you are hereby informed that the following person is arrested in connection with case and panel section. Gias Ali, he is a writ petitioner, 51 years. Date and time of arrest, 4th of May. His submission was that he was arrested on 10th and as 48 hours was not, has not elapsed, he was not suspended. It is an incorrect statement made before this honorable court. He was arrested on 4th and his release order is at page 36 of the writ petition, their own record. The bail order of 12/5/2023. Page 37, third paragraph I would like to read. On perusal of the case diary, it is seen that all the required evidence are documentary because bank transaction, all the monies was diverted to the account of the accountant, which were supposed to go to the school's account. Third paragraph, on perusal of the case diary, it is seen that all the records, evidence are documentary ones and all the documents which are to be obtained for digital ones, so that there is no possibility of hampering and tampering of evidence of the accused. Prior to arrest of the accused, IO stated that manual register was to be obtained, but it is seen that IO did not seek the custody of accused for recovering the missing register, nor tried to interrogate the accused in judicial custody, which shows that there is no need for detention of the accused on judicial custody anymore. On that ground, Lordship, he was released after 6, 7, about 8 or 10 days. Thereafter, he was also not submitting the register also, page 39. From the inspector of schools, it was written to her, him, Gias Ali, regarding the RIDF file. It has been noticed that you have stated in your reply dated 28 May 2023 regarding RIDF file, which you have discussed with me, but it is clear that you have not discussed about the matter with me. I have not received any file relating to RIDF from March 2023. You are asked to submit the same. This file is also missing. Then so cause notice was actually it is not required because in case of contractual employees, Lordship, they do not come under the 1964 disciplinary and service rules, Lordship. They are governed by the contract agreement. And the contract agreement very clearly says, Lordship, it is for 11 months, whether it is renewed or not renewed, thereafter they are continuing till May or till the impugn order was issued. But it is always page 30, page 26. Page 26. Deed of agreement executed on 1st January 2022 to 30th November 2022. If Lordship is pleased to come to clause number 1, that on and since the execution of this agreement of the second party shall act as finance and accounts officer of accounts SSA Dibrugarh, component in district mission office SSA Assam under the first party, so and so, subject to continuation of the scheme or subject to earlier termination either on the ground of unsatisfactory performance or on medical or disciplinary ground or on attainment of normal age of retirement. Further, who have already attained the normal age of retirement, that is 62 years, may execute this agreement, however, with a caveat that such deed of agreement shall be subject to outcome of petition so and so. this agreement will automatically lapse on 30th November 2022 afternoon. So the period is over. He is a contractual employee. There is no dispute regarding his status as an employee. So in that case, Lordship, if we have to remove him also, I think there is a clause where we can give him a 1 month's notice, and in lieu thereof, that clause number 6. Clause number 6, page 27. If the first party has to terminate the agreement at any point due to misconduct, insubordination, dereliction of duty, misreporting, misappropriation of SSA fund, or negligence in duty by the second party, the first party shall proceed with terms of the order dated 14/8/2015 to terminate the second party, and the first party in doing so shall not be liable to pay 1 month's remuneration in advance in lieu of the notice of above mentioned. So during the course of the contract period, we can also remove him with a 1 month's notice, and if we do not give the notice, then we have to give them 1 month's salary. But in his case, his period is already over. So what we are doing here, not terminating. As his period is over, we have said that we are not continuing or we are not renewing your agreement. That is our case. Our record will reveal, only because we do not want to put any stigma. That is why the record will also reveal the same thing. If Lordship is pleased to look at the termination order or the discontinuation order, page impugn order, which is challenged here, page 52. June 2023. Mohammad Giyas Ali, Finance and Accounts Officer, SSA, is hereby released from the contractual period on account of his lapse of contract agreement on 30/11/2022. This order will come into effect immediately. If you had written here that because of such his involvement in a police case or misappropriation of money, then the thing would have been different. So we are simply saying that you are discontinued because your period is over. The internal thing, Lordship may examine the records. Otherwise, it will become very stigmatic for him. Suppose he gets acquittal in the police case, then it will be stigmatic. But if he is convicted, then there is no issue. But if we are taking any action against him on the basis of the police complaint and all these things, then we should have given a show cause notice. But because the contract period is not in force, so that is not required. The law is well settled by series of judgment of this honorable court at the single bench level, division bench, as well as the honorable Supreme Court. So he does not have any indefeasible or enforceable right to seek a mandamus from this honorable court that your agreement period should be further extended. The law is well settled. The reason behind is that, Lordship, we have analyzed a person like him who is at the helm of affair, diverted 30 lakhs of rupees into his own accountant's account when the money should go to the respective schools. There is no dispute on that, and he cannot say that I do not know. He is at the head. He is at the top of the position. All the checks, everything, he is the custodian. And the main record, main register, he is also now hiding. That RIDF register, which he is not giving now. So can that kind of a person continue in a public office where we do not have any confidence in his credentials, his conduct, and his working style? It's an open and shut case that when the money is diverted from the person's account where it should be actually debited, it has gone to his own person. There's a conspiracy. All these things are happening. The accountant and the finance man, accounts and finance officer were involved. No other officer or no other person is responsible for maintaining the accounts of the office. So this is our case. Lordship may look into the records also, but we are not disclosing everything in the affidavit because we do not want to make it a stigmatic case at this stage. And there is no requirement for us to give him a show cause notice or draw a departmental proceedings. as because he is a contractual employee. Had it been a regular employee, Article 311 would have been attracted. The other provisions of Section 6 and the procedures laid down in Section 9 of the 1964 disciplinary and appeals rule will be applicable to him. But so far as because he is not a proper member of service, he is not a member of service till now, because his service is contractual for a limited period of 11 months, which was extended from time to time. And we have an appraisal system also in place. That appraisal system also he has said, he has indicated that rule. I'll place this also. Service regulations, financial regulations of Assam Sarva Shiksha Mission Assam. Here, continuation of employees on deputation, attachment, and further engagement of employees on contract in mission service. There is a procedure. We have to assess it. The decision is like this, Lordship. I'll place it, Lordship. I'll just read out. In case the decision of continuation of employee on the deputation, attachment, and further engagement of the employee on contract in mission service by the MD. So MD has the discretion also. Now, which MD will have a confidence upon this kind of an employee who is not maintaining the accounts in proper manner and rather diverted the fund for personal account of Dharitri Gogoi? The first person whose name was there in the FIR is the accountant, and her name is Dharitri Gogoi Saikia. So all this fund was transferred in and put in her account. It has to go to an X school, but X school is not receiving the money. It is received by Dharitri Gogoi. And who is the person who is preparing the check and sending it? The gentleman who is before his honorable court. So all these things are there. But we do not have to go into that nitty-gritties at this stage, because had he been a regular employee, that would have been the only option for us. That to throw him out or to discharge him or dismiss him from service, we have to suspend him, we have to dot a drippy, and thereafter we have to take a final call. But that right he does not have because of his status as a contractual employee. He is not a regular employee. So I'd like to place few judgments. Only 1 or 2 judgments will suffice. Once the contract period is over, he does not have any right to agitate before any honorable court to seek extension of his contractual period. (2011-15) SCC, page 180. Uttar Pradesh State Textile Corporation versus Suresh Kumar. Paragraph 6. Paragraph 6. In the facts of the case, we need not examine the effect of the order dated 26/4/1989, where the services of the respondent had been terminated as being stigmatic or not. As we are of the opinion that in the light of the facts that appointment itself was for a fixed period of 3 years, which should have come to an end on 6/9/1990. No relief beyond that period would have been given by the respondents by the tribunal or the High Court. We accordingly feel that the order need to be modified to the extent that the appellant shall be deemed to be in service up to 6/9/1990 and not thereafter. So his period was over on 30th of November 2022. There is a learned single judge's order. Relying upon this judgment, the Honorable Guwahati High Court, in the case of Imran Hussain Khan versus State of Assam, 2023 1 GLR, page 437. This is a very recent case, that is why, otherwise there is other series of cases. Here also, relying upon this Suresh Kumar's case, the Honorable Court said that no relief for extension of his engagement can be given by this court. The period of considering extension of the petitioner's contractual period had been left to the discretion of the responding authorities. So that is in paragraph 16 of this judgment. Okay. And this is a very relevant case, page 2018-3 SCC, page 218. Yogesh Mahajan versus Professor R.C. Deka, All India Institute of Medical Science. Here, paragraph 6, it is written, it is a settled law that no contract employee has a right to have his or her contract renewed from time to time. So this is the settled position. That being so, we are in the agreement with the Central Administrative Tribunal and the High Court that the petitioner was unable to show any statutory or other right to have his contract extended beyond 36/2010. At best, the petitioner could have claimed that the authorities concerned should consider extending his contract. We find that in fact due consideration was given to this, and in spite of favorable recommendations having been made, AIMS did not find it appropriate or necessary to continue with his service on a contractual basis. We do not find any arbitrariness in the view taken by the authorities concerned, and therefore reject his contention of the petitioner. So when there is a positive recommendation, then also he does not have a right. Paragraph 6. But in this case, it will be a suicidal attempt if we still continue with him on the part of the mission, because we cannot trust him being the custodian of the fund of that office. He was released on bail purely on the ground that everything is based on documentary evidence. That is why he was released after 8 or 10 days. So his detention was not required because everything is transacted through bank and it was recorded either digitally or through manual mode. So in that view of the matter, and the note sheet, Lordship, I would like to place, which is very relevant while taking this decision. Lordship is pleased to. I am placing that page 14 here. Also, we have stated in our affidavit also this line. Yes. This is my humble submission, Lordship. In that view of the matter, Lordship, there is no merit in the petition and it is liable to be dismissed.
No, first of all, my lord, all the submissions made, my lord, beyond the pleadings. None of these things have been, my lord, stated in the affidavit. In this affidavit, simply they say, my lord, one of the paragraph, I'll take your lordship to, my lord, paragraph 18.
Thank you.
Paragraph 18. The petitioner states that the entire action of the respondent number 3 in terminating the service of the petitioner is actuated with malafide in as much as not to speak of lapse of agreement period, the agreement of none of the employees of SSA have been renewed. However, all are continuously discharging their duties and responsibilities and have been receiving salaries. Now, reply to this, your lordship will find paragraph 17, my lord, of the affidavit in opposition. And the continuous page will be 62. Internal page 7. that as regard the statement made in paragraph 18 of the writ petition, the answering deponent categorically and emphatically denies any mala fide action against writ petitioner, and upon lapse of agreement on 30/11/22, the writ petitioner is released from service. That employee under SSA have been allowed to continue his service notwithstanding the expiry of the agreement period, as on expiry, his case for further engagement was under consideration. However, it would not give rise to an indefeasible right to the writ petitioner to be continued in mission service beyond the contract period, in as much as mission director SSA has decided not to further engage the writ petitioner on contract in mission service. My contention is specific that, my lord, while initiating the proceeding by issuance of so cause notice and reply, they have abandoned that, and to cut short the method, they have adopted, my lord, this process and issued this order. Now, whatever is submitted, none of the things are, my lord, here in the affidavit. How can, my lord, those can be relied? And my apprehension, for which I had approached this court and I have stated that it is because of the FIR, they have to, my lord, they have been issued this particular order. And whatever allegation is there, but I have to be proceeded under the disciplinary proceeding rules. That I'll come to that. But before that, one thing I'd like to clarify more, that I have made a false statement before this court that I have been arrested on 10. I have categorically stated in the paragraph, I don't know where from he has got that I have been arrested on 4. This is forwarding report. Well, this is the forwarding report, my lord. This was not that an issue, so, my lord, this was not, but I have stated, it was 10th. It is categorically stated that I have been arrested on 10th. In fact, they had issued a, my lord, notice under section 41, and they have interrogated. They have interrogated me, madam, and thereafter they have released me. Then subsequently, my lord, they have released, my lord, again arrested me, madam.
Where's the document that says
No.
he was arrested on 4th?
Yes, page 34 of the writ petition. This is their document, not our document.
Yes, it's
Page 34, date and time of arrest, 4th. Now, May 2023 at 10:30 PM at night. And it was prepared on the second last, Julie Dihingia signed it on 5th of May 2023. Page 34, annexure E1.
Who is this, Julie?
If he was arrested on 4th, he could not have been released at police station. The case was registered under 409. These are non-bailable sections.
Anyway, this will make a difference.
no, my lord, this cannot be read in isolation of the annexure. My lord, the context on which, my lord, I have said it is on page 8, my lord.
The
And
only
this-
issue now is what the Advocate General is submitting is that there are many things
Yes,
under the table.
yes.
He does not want to bring it out.
No, let him, my lord, that's what, my lord, it is, my lord,
He
he is,
is not interested to do that. And he's simply saying that since your contractual period is over
yes,
with effect from 30/11/2022, you were allowed to go.
whether,
Simple, without any stigma.
without this thing.
That's all. So the issue now is whether this court has to consider whether the contractual employee has a right to demand for continuation of the contract.
Yes. Well, so far as the submissions that have been made, my lord, firstly, my lord, these are, my lord, beyond records, my lord. It is, my lord, my lord, has been, my lord, submitted only to, my lord, divert the attention of the court to the core issue, my lord. That is the whole thing is, my lord, here. Rightly, Lordship has pointed out whether they have a, my lord, power to release me in this way without, my lord, having any proceeding, my lord. Only on the ground that the contract period has been, my lord, completed. Yes, the judgment those have cited, these are all distinguishable, my lord. On the first occasion also, last case that has been of DECA case that has been cited, that is a, my lord, simple contractual employment. But here it is not a contractual employee. They are governed by a service rule. They are governed by a service rule. I'll also place the judgment, my lord. Now here, Lordship, a set of service rule is there, my lord. Your Lordship will find even he is relying on the agreement. Your Lordship will see, my lord, the agreement, my lord. My lord, page 26. Clause 2, the party of the second part shall remain in contract from the date of signing this agreement. The party of the second part shall remain duty bound to carry out the work assigned by the first party in accordance with the duty craft of the respective competent design target set of the contract period. The party of the second part shall submit yearly progress report of timely implementation of activities in relation to the component. First party shall make proper assessment yearly on the performance of the second party. Second party shall endeavor and strive for contributing towards the fullest achievement of target, qualitative and quantitative, as said by first party during ongoing financial year. In case of any shortfall, the second party shall be duty bound to give specific reason, plausible explanation for the same if first party seeks explanation for it. These are the conditions, my lord. Even if you find in the ongoing some regulation of duties, then in that case, you give him a note that you do it in the next financial year. You improve your yoke.
Come to 6, condition number 6.
Yes. If the first party has to terminate the agreement at any time due to misconduct, insubordination, coordination of delinquent duty, misreport, misrepresentation, SSF fund of negligible in duty by the second party, the first party shall proceed with the terms of the order number so and so dated 14/8/2015 to terminate the second party, and the first party in doing so shall not be liable to pay 1 month's remuneration in advance in lieu of notice as mentioned above. This is the notification I have, my lord, pointed out, my lord, to your lordship at page 29. So it's 14/8/2015. Save as otherwise expressly provided in service regulation as financial regulation of Assam Sarva Shiksha Abhijan Mission, Assam. It is hereby notified that the spirit of the rule and procedure as prescribed under Assam Service Discipline and Appeal Rules 1964 followed by Government of Assam for inquiry, departmental proceeding, award of punishment, appeals, etc. shall be followed by ASAM as and when an inquiry of departmental proceeding are required to be conducted in respect of any employee, contractual or otherwise.
So they did not invoke this agreement number 6.
Yes. So the
Yours, because yours was a termination simpliciter on the ground that your contract period is over.
that power they do not have. That's what my submission. None of the agreement, even my lord, your lordship has seen the regulation. Here nowhere it says. Rather, what they says after completion, you take an assessment for continuation.
That assessment was done here, isn't it? The managing director has taken a decision.
Managing director is not the procedure has been given in paragraph 8. In paragraph the rule 8, they have said the review, comment and review of the CEO to be taken before the EC, then a decision will be taken. And now here, thing is, my lord, is my lord, what he has submitted, that certain allegations are there, which are, my lord, misappropriation of funds, etc., dereliction of duty, misconduct, everything constitute. If that be so, you terminate in that way. He should not be feeling shy that, my lord, to put all those allegations against me, my lord. He should not be shy. I have my explanation, my lord. The funds are diverted to the, my lord, accountant's account, personal account. It should have gone to the school, but it had, my lord, gone to the, my lord, account of that particular, my lord, accountant. The officer DMC, my lord, it was reported by the accountant to me. I have verified the things and I have reported to the DMC, and thereafter, on her request, I have conducted the inquiry. This is all said. And thereafter, the FIR was filed. And thereafter, the FIR specifically against that particular Gagoi, who was the accountant. And, my lord, the reason what they have been in the so-called reply, what they are saying, that for release of the fund, 2 signatures are required. One is mine and another is the DMC. There are seven documents under which, well, these are all, what the submissions are made, these are all replied by my so-called reply. So these will be considered, and thereafter the submission made or the decision already given by the Advocate General, that he cannot be retained, my lord. So that decision, let it come in, through in, my lord, disciplinary proceeding, my lord. I'll revert to it. Am I not entitled to that, my lord? This is, my lord, case, my lord, so far as our High Court also in a similar SSA matter, my lord.
No, the issue is this, your contract period has expired on 30/11/2022.
Yes.
Was it extended? It was not extended.
Not only me,
So
throughout Assam,
maybe
Lordship, my lord.
maybe others were not extended, but does not mean that they cannot take steps against you.
My lord, unless they have reasons to, my lord, terminate. That is the thing, my lord, the reasons to terminate. So therefore, my lord, reason is given what? Reason is only that the term has expired.
Yes.
On record, the term has expired. Well, if I have been singled out and rest all the employees, more than 5,000-10,000 employees are under the this particular SSA, or maybe more than that, they are continuing, and only in my case.
And this clause 6, it is in respect of termination. If
No, that's
that-
what I'm saying.
Yes, if it was within that contract period, then if we are releasing him, then the termination word will be effective. Now we are not, what we have used in our letter is a released. We have not terminated him. We have released.
I am on Rule 8. That gives me a right to be considered for continuation of the second term. Yes, sir.
Lordship decides we can place everything on a additional affidavit.
No, why here, my lord, let them, so-called reply already, my lord, I have submitted.
No, if you want them to come out with everything,
Yes.
then like AG has suggested, we can ask them
We
to
can-
file an affidavit.
My lord,
Which will be detrimental to his interest.
Can they, my lord, go, my lord, behind the pleadings they have made in the, my lord, before this court, my lord, is on
After
record.
hearing parties, I'm directing the Advocate General to place the same on record.
Yes, my lord. Yes. So the cause that it is not simple that the term has expired, but the cause is something else. It is not the
Yes.
cause that the term has expired, but the cause is that something else.
Problem is that.
And for which,
Yes, I'm sorry.
my lord, there has to be, my lord, there has to be some procedure, my lord.
No, Saikia, I think this one is not a very good case.
No, my lord, my lord, I'll submit, my lord, one of the, my lord,
No, without going any further, if
Yes.
you want the Advocate General to file an affidavit,
Lordship.
we can have it. But that may not be good for you.
That may not be good. That is what we are trying to avoid.
My lord, I have been terminated, my lord, I have been.
We have not terminated. He is
My
within
lord,
the wrong.
I am out of, my simple thing is I am out of service, my lord. I have nothing to lose anymore, my lord. What they are saying is the allegations. Firstly, these are under investigation before the criminal court. And secondly, they have, my lord, initiated the proceeding. They could have continued it. by putting all these things. What is there in the record, it is, they could have come up with that. Now, if they're relying on these documents, yes, my lord, let them submit an affidavit by bringing all these things in record.
Okay. But Mr. PJ Sarkar, the senior counsel assisted by Mr.
RS Mishra.
RS Mishra, learned counsel for the petition. Stop. Also heard Mr. D. Sarkar, learned advocate general, assisted by Mr. R. Bora.
Yes.
S. Bora, learned standing counsel, assistant. Stop. Why this writ petition? The petitioner is assailing the order dated 19/2023, by which he was released from the contractual service of SSA on account of lapse of country factor on 30/11. Stop. It is the case of the petitioner that the petitioner has rendered 21 years of service in the present post by extension of his contract agreement, well, time to time. Stop. However, comma, due to an FIR which was filed with regard to deposit of amount of rupees 30 lakhs,
Not 30 lakhs.
About 30 lakhs.
of about 30 lakhs in the account of the, in the account number of.
Private account of the
in the
accountant.
Private account number of the accountant by the petitioner. comma. The petitioner has been
No,
released.
not, FIR is not by the petitioner, my lord.
Okay.
My lord, the FIR
I'm
is
saying on the basis of an FIR.
page 32, my lord, is the FIR. My lord. FIR
That's
was
what-
lodged by DMC, my lord,
That's why I'm saying on the basis of an FIR.
lodged, my lord.
Stop, by which the petitioner has been released from service. Stop. Mr. D. Cycle and counsel, advocate general Assam. On the other hand, submits that if the factual truth as revealed in the records, as there are, if the factual truth of the records are revealed in an affidavit, the same would not be in the interest of the petitioner. And therefore, he submits that as the contractual period of the petitioner has come to an end, he was released from service. He was released from service of his contract employment. After hearing the parties, this court is of the consider opinion that the respondents should file an additional affidavit in opposition, explaining in detail the reasons for releasing the petitioner from service from his contractual service. How long can you file it?
Within 1 week.
Accordingly,
By Wednesday, we'll file, let the matter come up on Thursday next.
release the matter.
My lord, I may have to go through, may have to, my lord, additional
I'll
affidavit.
just say, I won't fix a date then.
My lord, he's filing by Wednesday, my lord, the week next, my lord, any date that can be, my lord, fixed.
This matter again on 24th. Understood.
Highly obliged.
Alright.
Item 12,
Make please, your lordship.
Yes.
Lordship, in the order not complied with, lordship, the relevant portion page 34, may kindly visit, page 34.
Look, here we are filing our affidavit, our Oklahoma soon lordship. We have received the Oklahoma. That instruction, like, we are waiting
1 minute.
for respondent one.
Okay, heard, Mr.
I am R. Islam, lordship.
I Islam and the council. Mr. SMD Chisti and the council submits that he'll be filing Bangla
For one only, respondent one.
on behalf of the respondent number 1. So, within
We'll file it by next week, lordship.
a period of 1 week. Accordingly, this letter
After 2 weeks, lordship.
after 2 weeks.
Obliged.
Lordship, your date may kindly be fixed, lordship.
We'll see.
Husband of the
Now,
petitioner.
no affidavit has come, nothing has come.
Lordship 2014, lordship. A date may kindly be fixed, lordship. Your lordship was
22
pleased.
matter, lordship. Yeah. It will come.
13.
Wait, please, your lordship. Lordship, I am the writ petitioner in the connected, I'm appearing for the writ petition. Lordship, I have not received any copy of IA filed by the private respondent, your lordship. I
Well-
saw the record where only elementary department has received the copy. Copy may be supplied to me, your lordship.
Have you
But
finished?
I am not pressing the IA now, Milord, because that was for vacation of stay. I am on the merit of the matter, Milord, because as stated earlier, Milord, on the last 2 occasions, my learned friend was not here. It is a case where the impugned order has been passed, giving me the benefits of provincialization by the SLC. And under the provisions of section of the Act, Milord, the matter is appealable. So on that ground, Milord, matter can be taken up.
You're not pressing your IA.
In that case, I will not press my IA, Milord, because that provision is there, Milord,
Section,
section 14,
that appeal.
appeal provision. Because see,
What is there in the writ petition?
Lordship, writ petition is filed, being aggrieved by the act of DLC.
I will pass the, I'll read the order, Milord. Initial order, that was 1/6/2019, 2020,
1/6
1/6/2020, Milord.
of
The
this
first order,
court's order.
court's order issuing the rule, issuing notice. There, Milord, it is stated. The petitioner is an assistant teacher of the Bangarpara ME Madrasa, teaching the subject of social studies. He has been in employment as assistant teacher in the school on and from 24/12/2005. For the purpose of provincialization teachers of the school, the headmaster has submitted application along with the list of teachers. The district curriculum committee prepared a report after making necessary verification and found the petitioner along with 3 other teachers as eligible for provincialization. When the matter came up for consideration by the SLC, according to the petitioner, his name was dropped. It is alleged that as against the name of the petitioner, the respondent number 9 has been who is the assistant teacher teaching Assamese language, got his name substituted, and the name of respondent number 9, the headmaster himself. The respondent number 8, that is respondent number 8, got his name substituted. The alteration so made according to the petitioner has been at the instance of the headmaster, who otherwise is not eligible for provincialization, as the number of students in the school in question do not exceed 100. From the document annexure 1, it stands clear that the petitioner was found eligible for provincialization as assistant teacher on the subject of social studies. So on that basis, notice was issued. Now the SLC has rejected the prayer and has provincialized the services of 8 and 9. Against that, the petitioner has come. So against that, SLC's decision,
No, your
Oh, you'll have to file an appeal.
No, that portion is not fully clear. What is submitted by my learned.
No,
senior
what is
friend.
happening is
I have
this.
read the order only. I have not
You are
submitted
against
any.
the provincialization of respondent number 7 and 8. Correct. Your name was recommended by the district level committee.
Lordship.
State level committee instead dropped your name and provincialized the services of the 7 and 8. Correct. Now you are claiming that there was some manipulation by the headmaster. Isn't it?
Lordship, what I want to submit before this honorable court is that DLC recommended my name. But prior to the finalization of the list given by the SLC, it has come to the knowledge of the present petitioner that his name was deleted, but till date, no picture is clear as stay order was given by this honorable court. SLC has not yet declared anything. And as per the, actually, there is a role of the elementary department to give the clear picture who is actually entitled.
Where is the provincialization order of the respondents? Have you furnished a copy? Have you annexed a copy?
It is not yet given by the state level, that's SLC, your lordship.
SLC has not yet
No.
taken a decision.
Because stay was given by this honorable court.
Where is the stay?
That is the first order, your lordship. I do not have the order copy with me. It is in record, your lordship. And as per the oral submission made by the elementary department, this school cannot be provincialized due to some land problem, your lordship, which do not fulfill the criteria as per the oral submission, but till date, no affidavit has been filed by the elementary department, your lordship.
Then, Mr. Chalia, I don't think it's a case of section 140, section 14. If the SLC has not taken a decision yet.
Because stay was given by this honorable court, so no decision was taken.
You came to court before the SLC took its
Yes, your lordship.
decision. DLC recommended your name.
Yes, your lordship. It is on record, your lordship. If your lordship will peruse page number 26, your lordship, of my
I'm
writ
on
petition.
page 26.
Name of the petitioner Rahul Amin. He was recommended as social studies teacher, your lordship. And the name of the headmaster, that is the private respondent, lordship, he was recommended as English teacher. So how he can take my place, your lordship, now? If he
No.
can provincialize, he can go for English subject.
No, after that, what happened?
Nothing happened, your lordship. Stay was provided by this honorable court. Later on, no decision has been taken. And the matter was fixed for admission. In the
So
meantime,
before the SLC took a decision, you came to court.
yes, your lordship.
On what basis?
On the basis, your lordship, that as information provided by the department that Abdul Rashid named, who is a private respondent, his name is going to be recommended for the post of social studies teacher, which is mine, your lordship. And in this regard, lordship, I have submitted several representations also, but that was not entertained by the department, your lordship. So being aggrieved by that one, I appeared before this honorable court.
Yes, who appears? So let the SLC take a decision, then after that only your course of action will
Yes,
arise.
your lordship. Within a specific period of time frame may be given and let SLC take the decision. Who is actually entitled? But stand of the elementary must be there, but your lordship, no affidavit till date has been filed by them.
What is your stand?
Lordship, let them submit before the court any instruction which they might get from the department. As this will ease the work of this honorable court, at the same time, it will give a clear picture who is actually entitled, your lordship. Otherwise, what happened, your lordship? Representation goes there with the High Court
No,
order
no,
and they do not do anything.
Department can't give a picture about who is entitled because matter is sub judice before the SLC.
Yes, sir.
SLC will have to pass an order.
That may be done within a
That direction
specific
can be
time.
given by your lordship. That direction can be given by your lordship,
Huh?
Within a specific time frame only.
giving a time frame.
30 MS
KJ.
in the main lead petition. KJ, London Council for the petition. Also had Mr. J. Beku, Leonard Standing Council. Elementary education. For the respondents. 1, 2. One, 2, 5. 1, 2, and 5.
See also. 3 or 4 and 5.
1, 2, 3. And 5.
Deputy.
Who appears for the government? Mr. V. Cycle and government with appears for respond number 5. Mr. R. Southern government. Appears for the respond number 5. And Mr. DP Chennai for the respond number 4. And Mr. DP
4 and
Chennai,
6.
then a senior
4
counsel,
and 6.
assisted by MS Emra for the respondents.
7, 8 and 9.
7, 8, and 9.
7, 8.
7, 8, and 9. Stop. Para. The petitioner is presently serving as a social science teacher
Yes, sir.
at Bakanpara ME Madrasa. Stop. Petitioner was initially appointed by appointment letter dated 23/12/2005, to which post initially appointed as assistant teacher by appointment letter dated 23/12/2005, to which post petitioner joined on 24/12/2005. Stop. Para. In terms of the Provincialization Act of 2017, within bracket 2017 in short. The headmaster of the concerned school submitted applications along with the list of teachers for provincialization of the services of the said teacher, of the services. Stop. Thereafter, comma, the district scrutiny committee after making verifications made a report whereby the petitioner along with 3 other teachers were recommended for provincialization as tutor. Stop. In the said recommendation, comma, petitioner was recommended for social studies and the respondent number 8 for English and respondent number 9 for language subject. Stop. It is the case of the petitioner that when the matter was being considered by the state level scrutiny committee, the petitioner's name has been dropped. And instead, the state level scrutiny committee was contemplating to provincialize the services of the respond number 89 as respond number 8 as was teacher.
Respondent number 8 who was serving as a headmaster, your lordship.
Okay, okay, 8 and 9, stop. However, comma, till date, the state level scrutiny committee is yet to take a final call by making any recommendation. For as the state level scrutiny committee is yet to take a final decision in the matter. The matter is, this writ petition is disposed of, remanding to the state level scrutiny committee to take a final decision with regard to the provincialization of the teachers of the set Pakanbara ME Madrasa within a period of within a 3 month or a period of 3 months after verification of all documents. Stop. That much will do, I think, with the aforesaid obligations and directions. We should discuss.
Deeply obliged, sir.
In view of the order passed in the petition, in the amended petition, I stands disposed.
The order passed earlier will be repeated. The order passed earlier will be repeated.
Yeah, interim order passed, yeah, stands pending.
Twenty-three of supplementary list order.
Have you filed your amended?
Yes,
post
yes,
title?
supposed to file amended petition, lordship. আপনাকে amended petition file করার কথা আসলে। There's a direction.
Have you filed your amended cost title? You have to file only an amended cost title.
No,
not a
because
whole-
Already we have taken a stretch, my lord. But not amended petition, my lord,
They have not filed, lordship.
not filed, my lord.
You are supposed to file an amended cost title.
Yes,
Thereafter, I'll issue notice.
my lord, with, 1 week time may begin, my lord.
Okay, Mr.
Take it up to my lord.
AK Datta Learning Council with the petition. Praise for 1 week time to file an amended cost title
Master order to supplement.
in terms of the order 5/8/2020.
5/8/23.
Praise the Lord. Please step to 1 week.
Obliged.
24.
May I please, your lordship?
Yes.
We have filed an IA for modification of the cost title of the writ petition, your lordship, bearing number 4247/2023. Actually, the father's name of the petitioner number 2 has been wrongly written as Nazar Uddin in the writ petition. Page number 4 of the writ petition, your lordship.
In the writ petition.
Yeah, page number 4 of the writ petition, your lordship.
This has not come up at any point of time. This writ petition.
This has come, your lordship, and order has also been passed by this honorable court.
Yes.
So the correct name is Mazur Uddin, your lordship, which is written in page number 6 of the IA, your lordship.
You want to correct the course title?
Page number 6 of the IA, Your Lordship.
Yes.
Paragraph number 3, Your Lordship. The father's name of the applicant number 2 in the course title has been written as Nazar Uddin instead of Mazur Uddin. And Your Lordship, in the order sheet dated 28/7/2023, the total number of students for the year 2023 and 24 has been wrongly written as 299 instead of 291.
Which order sheet?
The order passed by this honorable court on 28/7/2023. Your Lordship.
Where is that order?
It has been annexed as annexure 1, page number 10 in the IA petition. Your Lordship. Page number 10, Your Lordship. IA petition. Kindly see page 12.
Oh, this writ petition has been disposed of.
Yes, Your Lordship.
The disposal order. 42, 47. Okay, modification of that prayer, that portion where it has been written as 299 instead of 291. Which part is it?
Modification. Not school education.
How can I have a correct, how can you have a correction of the writ petition when it is disposed? By way of an IA. This is one problem that is coming up every now and then.
And leave this up to you.
The course title is already correct. The writ petition is already disposed. How can we have a correction of the writ petition now? Correction of the 299 instead of 291 in the order, that's fine. But correction of your father's name in the course title of the writ petition, which is already disposed, can you have it done by way of this IA?
I leave it to you, Your Lordship.
What do you mean by leaving it to me? You've made a prayer. You've made two prayers.
Yes, Your Lordship.
How can we have a correction of the writ petition? Course title of writ petition, when is it disposed? You think about it and come back.
I'll take instructions, Your Lordship.
Mr.
Assure, Your Lordship.
S.
Sure.
Sure. Let us counsel for the applicant. Press for,
MU Mahmood. Your Lordship.
press for, how much time?
To 1 week time, Your Lordship.
Press for 1 week time to receive instructions. Press a lot.
20, 21, and 22.
Hey, please, your lordship.
Other side is here.
Lordship. It relates to the rejection of NOC for opening of pharmacy college, lordship. By virtue of the order dated 28/2/2023 of this honorable court, directed for re-inspection of the institution, lordship. My respectful submission,
Which
Lord.
order?
order dated 28/2/2023, lordship.
20.
8/2/2023.
28, 2000.
May I pray lordship item WPC number 1998. Item number four, cause list of the- Item. Item number lordship 20.
28 to 2003.
WPC number 1998 of 2000, item 21 may be taken, lordship.
1 minute. Yes.
Lordship. Item lordship, item 21 may be taken up first, lordship, because they have filed their affidavit there.
Yes.
Lordship, the rejection order is page 231, lordship. 231. In their last additional affidavit. Lordship, may I read, lordship?
Yes.
With reference to subject cited above, I have the honor to state that as per instruction of the inspection committee constituted by government letter so and so, so and so. Accordingly, I submit here with an inspection report as submitted by the inspection team on feasibility of starting of B Pharma and D Pharma courses by HMAK College of Pharmacy, Dental and Medical Science, Nagaon, as desired by the government. The following deficiencies pointed out in the inspection report by the inspection committee. Deficiency in qualified faculty members as per PCI norms. Inadequate infrastructure faculties for starting B Pharma and D Pharma courses as per PCI norms. The inadequate books and journals for starting B Pharma and D Pharma courses as per the PCI norms. In this regard, considering the deficiencies in the inspection report submitted by the inspection committee, I am of the view that at this moment, NOC cannot be granted so and so. Then Science Nagaon for starting B Pharma and D Pharma courses is applied for. Lordship, with all respect, lordship, in the said writ petition, page 40, I may clarify it. Lordship, the
1
pharmacy.
minute. Who is the inspection report?
Earlier in inspection report, lordship, page 44.
No, page 232.
Next page, the inspection report starts from the next page of the letter, my lord.
Next page of the inspection report, page 232 onwards. Lordship, the points they have raised
Yes. Yes.
Lordship, just I am clarifying, Lordship, the Pharmacy Council of India already approved this petitioner's institution up to 2023-24,
That's fine.
Lordship.
Now that you can start only after NOC is given by the.
Lordship. Then Lordship also, I am coming, page 43 of the earlier inspection report, where my institution was fine, everything fine.
Earlier inspection
let me-
report was in dispute, right?
Lordship, just I am coming, Lordship, on that. Page 43 of my writ petition. Lordship, may I read, Lordship?
1 minute.
Huh?
Internal कोई दिन से
Yes.
Lordship, page
But
40.
Mr. Majumdar,
Lordship, please.
new development has come out now.
Lordship, Lordship,
This letter of 2023
Lordship,
by the director,
Lordship,
page 231, and the inspection report.
Lordship.
If you are not satisfied with this, you'll have to challenge this. Isn't it?
Lordship, it is a continuity of process, Lordship. So with all respect, Lordship, repeated writ petition, 3 writ petitions, Lordship, with all fairness, I am submitting. I have denied all these allegations. In my,
Where have you denied your?
Lordship, in my affidavit, Lordship, I have given the affidavit, Lordship. And prior to that, Lordship, I am coming. Lordship, there are other institutions which were given NOC. Just Lordship, page 206, whether how they were allowed, Lordship, from 206 to 162. 209, 10, 211, 12. Lordship, kindly consider that.
Yes.
206, Lordship, may I read? With reference subject cited above, I am directed to convey no objection of the government in medical education research department for starting degree diplomas so and so institute. And the institute shall fulfill all requirements with regard to the physical, clinical facility, technical, as led on government so and so within 1 year from the date of the issue of this NOC. In spite of having all this, Lordship, they are allowed, but we are discriminated. And with all respect, Lordship, once the PCI is an autonomous body who has found entire things are justified for which approval was given, and that NOC of the state government is a mere formality, Lordship, like
1 minute. Somewhere I've read
Lordship,
some fake medical this thing,
Lordship,
pharmacy.
I'm
Post-
coming. That one. Some notification came. Or I have challenged in another petition regarding the institution, Lordship. They have come with another notification for giving to it to the Shankardev University, Lordship. I filed their case there. In that case, is separate regarding approval of the university, Lordship, affiliation of the university.
1 minute.
And apart from that, I submitted my reply.
1 minute. Just
Lordship, please.
What is this, DB Bora, your page 228? In your additional affidavit?
It's my affidavit, Lordship.
No, no, his affidavit.
No, 228. Oh, sorry.
Annexure B, my lord. You're referring to Annexure B, my lord.
Status report. Lordship, I am clarifying on that, Lordship.
What?
Some person, Lordship, filed a case, complaint case against me, Lordship, in which bail was granted by this honorable court, getting any materials in the criminal cases, Lordship. For that, Lordship, the institution may not suffer, with all respect, Lordship. And
Which page is it?
it is page 2, what regarding that part, Lordship, regarding 228, Lordship.
Ah. Who is the status report for 11/20/22?
So the annexure B, Lordship.
Police case, my lord.
Ah, where's it?
Yes, my lord. Annexure B, my lord. Annexure B,
Page.
article. Article.
Lordship, 312, Lordship.
312, my lord. My lord, 2 police cases were registered against the director of the institute, my lord. Because they have fraudulently, my lord, by showing fake bank accounts, my lord, they have obtained scholarship for around 1,700 something students, my lord. And that too, my lord, by issuing fake certificate, because they did not have the affiliation. Because the police team, my lord, they visited the concerned villages. Even they went to Arunachal because the petitioner is saying that they have got affiliation from a private university of Arunachal Pradesh. So regarding the 2 previous case, the entire status report has been detailed in this document, my lord. Because detailed investigation has been done, my lord.
But that as my referred, my learned friend, Lordship, the bail order 145.
Bail order after
No.
reasonable time, my lord. Because, my
Yes.
lord, he was
No, no.
apprehended, my lord,
Thank you.
thereafter.
Lordship, page 192. Mr. has shown that all necessary documents to prove that the allegation brought against the petitioners is baseless and the informant do not have any locus standi to file any such FIR before the police.
It is submission, not the
Lordship,
observation of the court.
Being, I agree with Mr. Sawyer that it is very doubtful that about the locus standi of informant to file such a complaint. Lordship, with all respect, just to deprive this petitioner from getting NOC, Lordship. Pharmacy Council of India has given approval, being satisfied with all these infrastructures and everything. And they have given all other institutes, some which I filed, 4 institutions, Lordship, they are given the NOC, Lordship.
Your lordship may peruse the status report. Every line is important, my lord.
Lordship,
They are, my lord.
But
these
regarding
things have been
regarding
reflected.
that case diary, at 2, Lordship, I pray. 2, Lordship, time is much obliged.
Next item, item number 15, Lordship. My colleague, Senior Advocate Indranil Chaudhary is appearing on the other side, Lordship. I'm told, Lordship, he is also not present, Lordship. It will not take much time, Lordship. If possible, Lordship will take another day, Lordship.
You mentioned it too.
Now it's coming. Open to the open to. Yes, now it's coming.
Now it's coming, Lordship. My respectful submission regarding the issue which part is not related with the NOC, Lordship. NOC Pharmacy Council has approved up to 2024, given approval. And there are some, I relied on some judgment of the Allahabad High Court as well as Apex Court that the Pharmacy Council is the authority to decide whatever the educational position. And they rejected my claim. Just I am coming, what are the points of that rejection, Lordship, of the NOC, which is not their part, Lordship, at all. Just I am coming, kindly peruse 231, Lordship, page 231 of their affidavit, Lordship, where they have submitted the NOC, rejection of NOC order, Lordship. 231, Lordship, in the affidavit.
Yes.
Just I am coming, Lordship. The following are the deficiencies pointed out by the in the inspection report of the inspection committee. Deficiency in qualified faculty members as per PCI norms. My respectful submission, Lordship, I am coming. Inadequate infrastructure facilities for starting of B Pharma, D Pharma as per PCI norms. Then inadequate books and journals for starting so and so, so and so. These three things, Lordship, which is a part and parcel of the PCI, Lordship. PCI has given approval. My respectful submission. My lord, these are the approval of the PCI, Lordship. I'm supplying that, Lordship, to them. After fulfilling all these Lordships, they have given the approval. And NOC that part, Lordship, regarding these 3 points, Lordship, it is not the part of the state, Lordship, to follow. (2024). So my respectful submission, these 3 points, that cannot be, Lordship, the state subject, Lordship. I'll show some judgment.
How can you say it's not a state subject?
Because NOC, that part is only a formality, Lordship. Because it is guided by the Pharmacy Council Act, Lordship. These institutions are. I am relying on some judgment also. I'm coming just on that. And my respectful submission, they earlier satisfied, submitted the inspection report, which I referred in page 43, Lordship. Everything is there. I am just victimized, Lordship. With all fairness, I'm submitting. And these 2 or 3 criminal cases, this honorable court, in their bail order, Lordship, after
Whatever the criminal case is there,
Lordship,
that is not the ground for not issuing the NOC.
Lordship,
That is not the ground.
Yes, that has not been. stated.
Lordship, so I am not arguing on that line, Lordship. Regarding that 3 points, Lordship, regarding the PCI
Look
guideline,
at the report. Look at the report. Look
Yes,
at the
yes, yes.
findings of the report.
Lordship. There's
Summary of the inspection. Look at
Yes,
page 34.
Summary of the inspection.
on the definition, 7 teachers reported, Lordship, the course has not yet been started. With all fairness, Lordship, without NSC, how I can start the college, Lordship?
Just read it.
And their degree were present. Out of 3 lecturers, 2 lecturers are not qualified because lack of teaching experience. Therefore, there is a total deficiency of as per PCI norms. Then, Lordship, my question is, with all respect, Lordship, I am raising how the PCI has given the approval, Lordship. How the PCI has given the approval,
Who appears for PCI?
Lordship.
No.
PCI is not a party here in this case, Lordship.
They have given their
You
approval,
and the
their
PCI party then.
Yes, my lord.
and apart from that, their part
And
is,
your lordship may peruse the prayer in the writ petition, my lord. It is not connected with this, my lord.
no, connected with, not
Because
that.
they have prayed for setting aside of the earlier
No, then-
earlier rejection order only. my lord.
Yes. Then I,
First inspection has been carried out.
No.
Where the deficiency has been detected, my lord.
then my affidavit is there. On their affidavit, I submitted their reply, lordship,
Who is the reply affidavit?
259, lordship, page 259.
$259?
Operative paragraph 5217, lordship,
No,
sorry, 261. It would be two.
your reply affidavit is not. here.
Lordship. 217, lordship. There was some page marking problem, 2 times page marking was there, lordship. 217, lordship.
217?
Lordship,
No, have you filed a reply to this affidavit?
lordship, I filed.
Additional affidavit.
Lordship,
This was filed on 26 July 2023.
lordship. There, I filed it, lordship, while they served the copy on me,
Is the reply affidavit filed?
lordship. Yes, OEC.
Huh?
Do not file করেছে যেটি আপনি দিছে 259 পেজ মে কাইন্ডলি পেজ লস
Page 2?
259 লস
59.
Huh?
259 is a continuation of this additional affidavit.
lordship. This my additional affidavit, that was the reply of their affidavit, lordship. Environments is their lordship. May I kindly peruse paragraph 5?
No.
Yes. Sorry.
Something is wrong. You filed your reply affidavit.
My lord,
217. Huh?
See, you have just one reply affidavit
Lordship,
that is dated 22/6/2023.
lordship.
But this affidavit, additional affidavit of response number 1 was filed on 26/7/2023. Have you filed a reply to this affidavit?
Lordship, they served the copy on me on, I'm just coming, lordship. 21/6/2023, they served the copy of the affidavit, lordship. And yes, additional affidavit of the government, lordship. 21/6. Then I filed my reply, lordship.
Is that correct?
It's my signature at 2 p.m.
maybe,
they
but
supplied.
it has been filed on 26/7/2023.
Subsequently, they have corrected it, lordship. Earlier they filed it, they supplied to me because I received it on 21/6/2023, lordship, with all fairness I'm submitting.
No, whatever it is.
Lordship.
I'm not saying anything on this.
Lordship,
But they filed it on 26/7.
lordship, but they supplied the copy to me on 21/6/2023. Because there was some translation problem was there. Yes.
Filing still আছে, filing
Filing still আছে, আমার copy serve না করাকে তো file করিব নোৱাৰে. Without serving the copy to me, lordship, they cannot file it. For which, lordship, I received the same. And
That is okay. I'm not saying you've not.
lordship, please.
But have you filed a reply to?
Lordship, that is my reply. Page 259.
See, how can you file your reply before they file the additional affidavit?
Because they serve the copy to me, lordship. For which I filed, lordship. Because of lordship, I am, with all fairness, I'm submitting, lordship.
I don't understand.
If necessary, lordship, then I will again file its reply, lordship.
You filed a reply then.
If necessary, lordship, with all fairness, I'm
But
submitting,
then, even if you file a reply, you don't have any case.
lordship. Again, resubmit my reply, lordship, then
My lord, otherwise also, this trace inspection has been carried out.
No, that's what I've been telling him
Yes,
from
yes,
before.
lordship,
Yes, my lord.
this
There's
is,
an order
yes,
saying you cannot be issued NOC, inspection report has been carried out, saying you have deficiencies.
lordship,
All right,
lordship. My yes.
now you will have to, you're required to challenge this too also.
Lordship,
It will create problem, it will create problem for you.
lordship,
My lord.
with all
If
respect,
they are
Lordship,
agreed with this inspection
let me-
report,
let
my
me
lord,
submit.
they have to submit
that,
it, my lord.
that inspection was made on the basis of this honorable court's order by virtue of this
Exactly.
Lordship. And it is a my respect to submission, Lordship, it is a continuity of process,
It's up to you. It's up
Lordship.
to you. That-
And then Lordship also, Lordship, because petitioner file one after another cases, Lord, they are passing the orders with all fairness. I'm coming just on some judgment of the apex court, Lordship, if please just allow me to refer
But are you filing reply or not? You are not filing reply.
of that, their affidavit.
Ah.
Though I filed it, I'll refile it, Lordship, as technically Lordship is correct. Since they have filed it on 2023, I should have to, because they served the copy on me prior to filing of that.
That's fine.
And I filed it, this is already in the copy, Lordship, in the
Because they filed only on 26/7.
Lordship.
And
So-
you couldn't have filed a reply before they filed. the
Lordship,
affidavit.
Lordship, please.
That's the whole issue.
Lordship, if necessary, Lordship, I may be allowed to file a reply of that again, a fresh, Lordship.
How much time you require? 1 week, 1 day, 2 days?
Only 2-3 days, Lordship, short date maybe, because I want to, Lordship, get,
We are trying to dispose your matter also. It's because
Lordship,
of all
with
this
all
problem-
fairness, a short date may be given.
Because of all this
Even-
problem.
My lord,
Otherwise,
even if they file a reply, my lord, if your lordship peruses the prayer portion, my lord, because the prayer cannot
Court
be
can
amended.
always mold the
They-
relief.
No,
With
no,
all fairness,
they-
I am submitting.
they
Court
cannot
have a entire power, Lordship, is a 226 petition.
No, my lord.
Lordship, they are passing
Your
one
lordship
after
may
another,
peruse the
Lordship,
prayer-
court
prayer
can
portion
always
of
mold
the
the
report.
relief because they raised the some pleas on that. So I may be allowed to file additional affidavit on that. Sorry, on their affidavit, if necessary, Lordship, within short date, Lordship, within 1 week.
Mr. K. Majumdar. Filing a reply affidavit to the additional affidavit filed by the respondent number 1. When do you want it?
Lordship, subject to convenience, Lordship, on today is 10th, Lordship. 15th is Monday. 15th,
Next week, there are too many cases fixed.
Lordship.
Many cases are fixed.
Next week, Lordship, subject to convenience, it may be on 17th.
There are too many cases fixed.
Lordship, please. Then Lordship, subject to convenience, short date maybe, Lordship, kindly consider. I want to get rid of that,
You want it on a hearing day,
Lordship, so that it can be finished up, Lordship.
24th.
24th, Lordship. Much obliged,
You'll
Lordship.
have to apply your mind, but you have to, during this period, you should apply your mind.
Lordship, Lordship.
Whether you're required to challenge the
Yes.
inspection
new
report.
report.
plus the letter of the director.
Yes, my lord.
They are two very vital.
Because
very
they are prayer, if they, we go by the prayer in the writ petition, my lord,
That,
they have to challenge the.
Because
legal.
the whole ground that you have taken in these 3 writ petitions,
Lordship.
these have been wiped out by this.
Final order, that
final
final
inspection
order.
Earlier
report.
rejection order that is.
So, Practically, this becomes infructuous.
In fact, that's my lord.
It has.
But
become-
my recital submission with all fairness, Lordship, I submit. Since it is a continuity of the writ petition, Lordship, after by virtue of this honorable court's order, therefore I filed,
With the new inspection report and the
Lordship.
letter of the director,
Lordship,
the whole that you have taken in this, it has been rendered infructuous.
Lordship, let me get,
You
think
think
of that.
about it.
think on that. Lordship.
Obliged.
16 of daily hearing.
Yes, G. Beku, have you reconstructed your file?
My lord, I have supplied all the necessary particulars, my lord, and he has already constructed the file. My lord, this is a matter of 2014, my lord.
Yes. So you're ready now today? Why? Just now he has been saying that this is a 2014 matter. I can't hear you.
My friend needs some accommodation. My lord, what has happened on the last day? From the very court, my lord, I have given the file to my lord that my learned friend could have get the crux of the matter, my lord. As my learned friend has expressed inability, my lord, today. My lord may hear my part, my lord, their part can be here on some other date, my lord.
That creates a lot of problems.
That's correct, my lord.
On 24th.
Okay.
Fine.
But yeah, we are the next also for the petition. Our request made by G. Bekul and it's something also. Elementary Education Department, list the matter on 24th. How about 5, 6 and 7?
My lord, my lord has already verified the record, my lord. Mr. D. A. Kayum entered appearance. Frequently, his name has also been reflected in the cause list, my lord, but they are not, my lord. Even I have personally informed also, my lord, one of his junior, my lord, but not turned down, my lord. Perhaps some issues may be there, my lord. Lacks of materials may be, my lord. That may be the reason, my lord. My lord. Oblige me.
17.
May I please, Lordship? Short issue involved in this case, Lordship. Earlier, several times this matter was taken up. Your Lordship has also gone through that, this writ petition, Lordship. My lord, the petitioner has already retired from service on 30/9/2015 while serving as assistant teacher. My lord, his promotion was due and thereafter, Lordship, the district elementary education officer has issued a letter, Lordship, that is page 19, requiring the petitioner to submit the willingness to promote for promotion to the post of headmaster. Unless that is page 19, your Lordship kindly come.
Yes.
This is the letter issued by the district elementary education officer requiring the petitioner to submit his willingness to serve as a headmaster. My lord, at that time, Lordship, I was suffering from various ailments, heart disease, cardiology problem was there. I expressed my unwillingness, that is page 21. 23/12/2003. Thereafter, Lordship, page 23, I have submitted my application for withdrawal of that application and praying for Lordship consider his promotion to the post of headmaster. That is page 23. And page 24, that is the receipt. Page 24, that letter was received by the inspector, district elementary education officer. And thereafter, Lordship, in that time, Lordship, another headmaster was appointed who was senior to me. Subsequently, Lordship, before his retirement, I filed another petition, that is page 25. That at that time, my promotion was again due. Page 25. Your Lordship may kindly come to last paragraph. I therefore pray to your honor to be so kind as to look into my case sympathetically so that necessary action may kindly be taken for my promotion as prayed for whose act of kindness I shall ever be grateful to you.
The first offer was for the post of headmaster.
My lord. Thereafter, Lordship, page 26, your Lordship will find this is the gradation list. In serial number 1, Bijoy Lakshmi Dev. And my name appears as serial number 2. And the private respondent's name, your Lordship will find serial number 12, Lakshmi Dev. My lord, since one candidate was senior to me, Lakshmi Dev, she was allowed to hold the charge of, Lordship, she was
There's a
promoted.
private respondent here.
No, Lakshmi, the serial number 1 is not the private respondent. Private respondent is serial number 12. Because our case is against that.
Respondent R5.
R5.
Anybody for R5?
My lord, several times on the last occasion also, nobody was appearing in this case. Lordship.
Last occasion, SK Ghosh was present.
My lord, last occasion,
Of course, last occasion he was not there. But on 18/7 he was there.
my lord, one day he was present. Several dates, Lordship, several dates he was not present. Only one date that your lordship will find that advocate was appearing. And she also retired. That's why perhaps not interested to.
She has retired.
She has also retired.
Petitioner and the
Both the
respondent.
petitioner and the
Both the
respondent
petitioner and respondent
already retired. My lord, I am praying for
Maybe
at
only
least
for the
lordship notional.
promotional benefit.
If I am entitled lordship, notional benefit may be given lordship.
Okay.
That's why I am praying in this case lordship.
So matter may be taken in other day, my lord. We are taking
Several
also-
times they have taken time. This is 2015 matter, more than 8 years
Private
lordship.
respondents, counseling also. have some-
Why they are bothering with the private respondent? You have to study your own. Yes.
You're not prepared or?
No, my lord, already both had already retired. and
Both are
they
retired,
also
there's no doubt.
Already.
But
we are
private
waiting for
respondent was
exam.
promoted as headmaster.
Yes. That is another lordship, if your lordship kindly come to page 28. As per gradation list, page 26. Serial number 1 was promoted, that is Lakshmi Dev. I am not against that Lakshmi Dev. She was promoted in the year lordship 2014. After that lordship, my prayer was routed to the lordship departmental authority, page 19. Director has issued this letter to the district elementary education officer to look into the matter of the petition, prayer of the petitioner. Thereafter, lordship, another gradation list was prepared, that is page 30.
3-0.
In the meantime, lordship, Lakshmi Dev retired. Serial number 1. Now, my position became lordship serial number 1. Abdul Karim Chaudhary lordship. Serial number 1, there was no teacher. So serial number 2, Abdul Karim Chaudhary, page 30. And the name of the private respondent, your lordship will find at page serial number 6, page 30. Thereafter, lordship, the imprint order of promotion was issued, page 36, on 25th March 2015.
Yes.
I am challenging this lordship promotion order. My lord, during this time, lordship, the petitioner retired from service. My lord, this is apparently appears that says her serial number was 6. She was promoted. My prayer was not considered because I had submitted my application expressing my unwillingness.
But you have withdrawn that.
Yes,
You have
That-
withdrawn in the month of February,
immediately, yes, lordship.
after 2 months.
Yes. Okay. It is a simple case, lordship.
Let's give one last chance to 5 pass apart. Otherwise, we'll pass ex party order.
My lord, may be recorded as a last chance, lordship.
Yes. Heard Mr. M. Khan, that is council. Also heard MSL Khan, that is studying council. None appears for the respondent. List the matter again on.
Lordship, can you do 17 lordship?
Next
Next, may I pray, lordship, this matter may be kept,
There are too many cases.
may be kept as part of lordship, because
No, ma'am.
your lordship has heard this matter several times, lordship.
Every time, every matter. Part.
I cannot have everything.
Several times this matter was,
17th. If respondent number 5 is not present on the next suitable date, this case shall proceed ex parte against respondent number 5.
under date
17th.
7. Obliged.
18.
Maybe your lordship, lordship matter may be passed over for that day.
Why?
Senior is out of.
Who's your senior?
R. Ali.
On request made on behalf of R. Ali. This is the matter after 1 week.
Awesome.
Twenty-five of supplementary hearing. Twenty-five
Maybe.
In this case, well, a similar situation is already decided by Honorable Justice P.K. Koteshwar Singh, my lord. This is the judgment. And you see, my lord, page 4, para 5, my lord. May I read, my lord? In the case, no such eventually has taken place, the benefits of provincialization has been sought to be taken away by state merely on the ground that no student in the said subject is available in the said school. Lack of student cannot be a reason for revoking the service of the petitioners unless the same is a policy decision of the state. Learned counsel for the petitioner submits that lack of student was not because of the fault of the petitioners. The fact remained that the authority cannot nullify the fact of the consequence of the provincialization in the manner as has been sought to be done by the impugned order, except by resorting to lawful manner. In other words, the provincialization of the service of the petitioner cannot be taken away by a reason of mention in the impugned order, and accordingly the petitioner shall be reinstated in the service as provincialized teacher in their respective school. The impugned order dated 27 so-and-so has been stayed by this honorable court at the time of issuance of notice, and such that the petitioner continues to be in service as provincialized assistant teacher, namely, so petitioner number 1, 2, 3, and their service has been utilized as school in which they were working was merged with upper primary school, and which their service has been utilized as regular teacher. As regards the petition number 4, the subject has been utilized in the school. In view of the above impugned order, so set aside with the direction to the authority to take place service of the petitioner in appropriate school without disturbing their service as provincialized as Hindi teacher, madam.
What is your case, sir?
Petitioner were Hindi teacher, therefore post were provincialized in the year of 2013, my lord. 2014, director of secretary,
Provincialization order?
my lord. Page 45, my lord. And exam 9, my lord.
Page?
45.
Yes.
This is the provincialization order, my lord. In respect of petition number 1, my lord. Next page, my lord.
Who is the petitioner number 1?
Huzuma Begum, serial number 7, my lord, below. Hindi teacher.
Then
Next, my lord, page 47. Rishi Kumar Upadhyay, my lord, serial number 9,
page 47,
my lord,
serial number 9.
my lord.
Is petitioner number
2, my lord.
2. Then
Then, my lord, page 49, my lord. Abdur Rahman. Page number 3, my lord.
serial number?
Page number 3, my lord.
Huh?
3.
Tayyab Ali.
Abdur Rahman, my lord.
Page 49.
49, my lord.
Serial number 3.
3, no, my lord. Below, my lord, 7.
Oh. Petition number 3.
My lord.
Then
Next, 51, my lord. Serial number 6, Alia Zebin Chaudhary. Is petition number 4, my lord. Then, my lord. So cause notice, my lord. Issue so cause notice, page 70, my lord, another 14, my lord.
Annexure,
14.
page
Page 70, my lord.
70. Read it.
My lord. Then impugn order, my lord, page 74, another 17, my lord.
Hmm?
Impugn order, common order was issued, my lord.
It's 30 June.
Page 74. 38 June 2015.
How many petitioners are here?
5 petitioner, my lord.
5 petitioners. Then what happened after this?
Therefore, I have filed this petition. Honorable court,
What is your position as on today?
I am continuing, my lord. We are
After-
continuing.
It's a stay order. no?
Yes, lord. Stay order was, my lord, 26/8/2015, my lord. But one of the petitioner, my lord, petition number 2, he has retired, my lord. Retired on 31/1/2019, my lord.
31.
31/1/2019.
Are these the same facts?
Lordship, same fact, my lord. They were the Hindi teacher.
Is it correct? Kaushik?
My lord.
Is this the same facts with WBC 5666?
Perhaps, my lord, but if your lordship, I don't know from the so-called notice, but here your lordship will find the statement
No,
of
no, he
allegation.
is saying that
My lord.
this case is covered by the judgment passing WBC 5666.
My lord, in my humble submission, my lord, the relevant rules, my lord, this rule 9 of the Assam Disciplinary Appeal Rules has not been taken into consideration in this judgment. So if your lordship allows me to take, your lordship to take so-called notice for a moment.
Anyway, let us
My
complete.
My lord, earlier, this order, my lord, this order had not challenged, they have not filed writ appeal. Till now, my lord,
Whatever it is.
they were the Hindi teacher. They were terminated. Allegation, same allegation, my lord. Lack of student. So my prayer is, my lord, covered case, my lord.
Your school has it been merged with any other schools?
Yes, lord. Now my school has been merged with ME school, my lord. Now we are taking class ME and high, both section, my lord. In this aspect, I have filed affidavit, my additional affidavit,
You file an additional affidavit.
my lord.
When did you file it?
3/8/2023, my lord.
What additional affidavit?
My school, our school has been merged with ME school, and we are taking the Hindi classes.
Where is it? Where is it? Where's your addition left? When did you file it?
3/8, my lord, on 3/8/2023, my lord,
2022?
23, my lord.
Then we can pass it out. When did you file it?
3/8/2023, my lord.
Oh, just recently.
Yes, lordship. This is the receipt, my lord.
Okay. Let it come on record. Since this was in the part 2 list,
Lordship,
they may not have been able to prepare it. Yeah. Mr.
A.K. Azad.
A.K. Alam
Azad.
Azad, Learned Counsel for Petitioners, submits that they have filed an additional affidavit on 3/8/2023. Registered to verify and place the same on report, comma, if found in order. Mr. B. Kaushik, Learned Standing Counsel,
Secondary.
appears for the second resolution. List the matter. 1 week, 2 weeks?
My lord, next Thursday, my lord, one of the petitioner retired, my lord, is due to pendency of this
Too many
petition, my lord,
cases- Too many cases are fixed.
he could not
Next
receive the pensionary benefit, my lord. That is the problem, my lord.
There is
list
no
the matter.
question of pensionary benefit under the 2011 Act. Comes under the new pension.
24th.
My lord.
Yes.
Sir, 2 weeks or 4 weeks, lordship.
Who's unwell?
Special PP, Mr. M. Halloy for CBI.
On request made on behalf of Mr. S. Halloy.
M. Halloy.
M. Halloy, Leonard, special PPCP, list the matter after.
After 3 weeks, Lordship,
After
we appear for respondent number 1 and 2. After 3 weeks.
After 2.
Highly obliged.
Mr.
Alright, on behalf of patient.
R.
Patient.
HID, Learned Counsel.
Sir, R. Ali.
2014 matter. Mr. R. Ali, Learned Counsel, on behalf of, appears for respond number 3.
Lordship, I appear for 1 and 2.
And Mr.
V.A. Chaudhary on behalf of A.M. Bora, Lordship. V.A. Chaudhary on behalf of A.M. Bora. Highly obliged.
Item 1, 2, and 3, hearing.
Is your lordship. Lordship, I'm appearing on behalf of my senior Miss B. Bhuya.
Mm.
As per her instruction, we have completed our part along with the written submission.
You completed your part.
Otherwise, for petitioner 1 and 2, lordship, the arguments were concluded, my lord. Only for the third accused person, my lord, the Mr. A. Kolita is appearing, my lord. He did not receive the paper book by that time, my lord.
Oh.
That is why, my lord, freshly the direction was made by the Honorable Court to furnish the copy, and thereafter his part, if lordship takes up, then, my lord, only he is required to do his part, my lord. The dying declaration case, my lord, 98 to 99% burned, my lord. That was heard in length, and we filed our written arguments also in this case, my lord. In item 1 and 2, written arguments are there, my lord.
Item 1 and 2.
Item 1 and 2, my lord.
Okay, written argument on behalf of state.
Oh, okay.
Then criminal appeal written argument. Who has filed this written argument?
For Moni Majumdar, the written argument has been filed, my lord, and for Mohan Biswas also, my lord, the
Mohan Biswas,
I have filed, my lord.
accused number 1.
He's accused number 2, my lord.
Accused number 1.
Item number 2, my lord. He's in item number 2. Criminal appeal number 15 of 2020, my lord.
Lordship. Lordship, I have been appointed amicus in item number 3, so number 3, Lordship.
It's item number 3 that is not completed, isn't it?
Somali Biswas. Somali Biswas, Lordship, I haven't started.
Paper book is the same.
Paper book is the same, Lordship. It's from the same FIR. So, Lordship.
Mr. Criminal liability 16.
Yes, 16, Your Lordship, 16 of 2020.
Yeah.
May I please, Lordship. So, Lordship, I will straight away take your Lordship. I take your Lordship to the FIR. FIR is at page 4. It starts from page 4, Your Lordship. So, complainant is Sanjay Pandit. The named accused are Mohan Biswas, Samla Biswas. There is slightly mistake in the thing in the name. It should have been Shamali Biswas, then Mani Mazumdar, and I'm appearing for Shamali Biswas, Your Lordship. Number 2.
It should be Shamali.
Shamali, it should have been Shamali Biswas.
SH.
SHYAMOLI.
Shamula.
Shamoli. Yes. So they have written Samla.
LI.
LI. Shamoli. So Lordship, page 5, the content of the FIR. So humble submission is that around 8:30 a.m. on 18/8/2014, the above mentioned accused persons came to my sister-in-law's house and quarreled with her over issue of laying eggs by their hen. The accused person set Ruby Pandit, my sister-in-law, on fire by pouring kerosene oil when my elder brother was not at home. As a result of which my sister-in-law jumped into a pond nearby to save her life. Hearing her scream, her neighbors lifted her from the pond and took her to Jugijan Primary Health Center. Later, she was referred to Guwahati Medical College for better treatment. Later, my sister-in-law died in medical college. My sister-in-law herself stated the names of the above mentioned accused persons before the doctor and the police. There is a FIR. No, Lordship, there are around 13 PWs. 13 PWs are there. So I will take your Lordship to the first PW, that is PW number 1. He is the complainant. At page 10, your Lordship will find. I am the complainant I am the complainant of this case. I know the accused persons. The incident took place around 8:30 p.m. on 18/8/18. Hearing a hue and cry in this is Ruby Pandit's house, I went and saw her naked body burning in the bank of the pond. Taking a gamocha, hand woven towel from Mohan, I covered her private parts. When we asked her, she said that Mohan Samali Mani Mazumdar set her ablaze. So Lordship, this statement, when we asked her, she said Mohan Samali and Mani Mazumdar set her ablaze. This portion is missing from the FIR, Lordship. This is the first point I'm just pointing out. So FIR, nothing has been stated about this. That when we asked her, she said that Mohan Shamali Mani Mazumdar set her ablaze. So this is not there in the FIR. Ruby is my Nobo. Nobo is elder brother's wife. When we informed the police at the police station, police came and took her statement. Later, we took her to Jugijan Hospital as per direction of police. From there, she was referred to GMCH, but she died on the way to Guwahati. So here, let's see, one statement has been made that when we informed the police station, police came and took her statement. That may be noted, dear Lordship. Police came and took her statement. In fact, police did not take any statement. Police hasn't taken. I'll just bring to your Lordship notice later on. The police did not take any statement. This is a statement he has made. The police came and took her statement, but in fact, there was no statement taken by the police of the victim. Later, we took her to Jugijan Hospital as per the direction of police. From there, she was referred to GMCH, but she died on the way to Guwahati. Police seized a gallon of kerosene, a burnt bedsheet, ashes of burnt clothes, and pieces of plastic sticking on sack of Ruby Pandit's house and took my signature. I lost the Ejahar in the police station on the day of the occurrence itself. Exhibit 1 is the Ejahar, Exhibit 1 is my signature. Therein, and Exhibit 2 is the seizure list. Exhibit 2-1 is my signature therein. The accused persons are Ruby Pandit's neighbors. Now let's see this cross-examination part. I lost the Ejahar at my elder brother, as my elder brother was busy in hospital. My elder brother is a carpenter. At the time of the incident, my elder brother was at Huzai. I cannot say when my elder brother went out of his work in the morning. My elder brother and sister-in-law got married about 11 years ago. They have 2 sons. At the time of the incident, both the boys were in my house. The distance of my house and my elder brother's house is about 50 meters. We are 4 brothers. 3 of us live together, and Ruby and her husband live separately. Here, Lordship, the distance of my house and my elder brother's house is about 50 meters, but there was no statement, or there was nothing has been stated about they have heard something about some quarrels, because a person was supposedly set ablaze. So like there was, but like he didn't say that like he heard anything, because house was only 50 meters away from this, his own house. So nothing has been stated on that. We did not hear about any quarrel that had taken place between the elder brother and sister-in-law. On my arrival at the place of occurrence, I met Mohan, Nitendra, and Viren Hira. I did not talk with my sister-in-law on the bank of the pond. So here he states, Lordship, that I did not talk with my sister-in-law on the bank of the pond. She said the names of the accused persons after she was taken home. At the time the accused persons were not there, but there were other people. So this is what he states in his cross-examination. So in his cross-examination, Lordship, that's 2 things, Lordship. I pointed out that as far as that When we asked her, she said Mohan, Shamuli and Moni Majumdar set her ablaze. That was missing in the FIR. And in his cross-examination, he states that like he has not heard anything about any kind of quarrel or any kind of hue and cry, because somebody, a person who is alive, who that the person has been put on fire, I mean set ablaze. So there should be some kind of hue and cry, but he hasn't, at least he hasn't heard it. Now let's see. Page 13 is PW2. PW2's evidence, Lordship will find page 13. So his name is Nitendra Vomik. So he states, I know the complainant. I also know the accused. The occurrence took place in 2014, around 8 AM. On the day of the occurrence, I was going to cut grass in the field. At that time, I heard a hue and cry on the bank of the pond of my house. Then I went to the bank of the pond. Biren Hira and Roti Sarkar also went to the place of occurrence along with me. Accused Mohan pointed to the pond and said that someone was there. Then we, that is Biren and I, picked her up from water. At first, I could not recognize her because her entire body was burned. Later, I recognized her as Piyush Pandit's wife. The woman asked why she had been picked up from the water, as she asked to throw her in water again. Later, I left from the bank of the pond. But this this witness has been declared hostile. So in the cross-examination part, in fact, let's say cross-examination by prosecution, what he stated was that it is not a fact that I had stated before the police after lifting from water. The woman had told, screaming, Mohan, Samna, and Moni set me on fire, and shouted. It is not a fact that I have adduced false evidence today. Cross by defense, the woman had not made any sound while she was lying in water. After 10 minutes of her lifting from water, she just said, throw her in water. The pond belongs to Ankur Master. He was ultimately declared hostile. Then let's see PW3 at page 15. His name is Biren Hira. I know the complainant as well as the accused. The occurrence took place at around 8:30 AM about 2 years ago. Mohan made a hue and cry, saying that someone fell down in water. Hearing his scream, Nitendra and I went near the pond. Both of us lifted the woman from the pond. The woman said to throw her in water again. The woman was not in a recognizable state, but later I recognized her as Piyush's wife, Ruby. Later, Piyush's brother took her home. At this stage, the witness is declared hostile. This person was also declared hostile as prayed by the learned PP. The cross by the prosecution, it is not a fact that I stated before the police that after lifting from water, the woman had told Mohan, Samna, Moni set on fire. It is not a fact that I stated before the police that later when people gathered, Mohan, Samna and Moni fled away. My house is situated about 200 to 300 meters away from the place of occurrence. I did not hear if Piyush and the accused had any quarrel. I did not hear about any quarrel between Piyush and his wife too. Ruby had not mentioned any name of any person. Because let's see, this person was also declared hostile because as per the PP, like he has retracted from his persons that he has given to the police. under 161. Now, Lordship, PW4 is important. To this case, PW4 is the doctor. At page 17, your Lordship will find. My name is Dr. Khalikuz Jaman Chaudhary. On 18/8/14, while I was working as senior medical and health officer of Jogijan PHC, on that day, I examined the injured person, Srimati Ruby Pandit, a 36 years old woman. On the basis of police requisition of Jogijan PP, the injured person was identified and escorted by Constable Ajit Bourbon of Jogijan PP. During examination, I found Ruby was responding to our questions and she was examined, burned, having 98% to 99% deep burn injury. So the person was burned 98% to 99% deep injury. After giving her first aid treatment of Jogijan PHC, I referred the victim to GMCH. As per my opinion, injuries were grievous in nature, caused due to burn. Exhibit 3 is the medical report submitted by me, and Exhibit 3.1 is my signature. At the time of examination of victim, I recorded the dying declaration of victim in presence of witnesses, as she was found willing to give the statement and she was also found capable of giving statement and declaration. So Lordship, the person is 98% and 99% burnt. But statement from the doctor is coming that she was found capable of giving statement and declaration. That Lordship has to look into that part. As per her declaration, persons namely Mohan Biswas, Syamala Biswas, and Mani Majumdar set ablaze her by pouring kerosene by entering into her house at 8 a.m. on 18/8/14. I obtained the thumb impression of the victim on the declaration and I endorsed the thumb impression. Exhibit 4 is the dying declaration of the victim, Ruby Pandit. Exhibit 4.1 is my signature along with the endorsement. So here, Lordship, this in the dying declaration, only declaration which has been made is that Mohan Biswas, Samala Biswas, and Mani Majumdar set ablaze her by pouring kerosene by entering into her house at 8 a.m. But nothing has been stated. Nothing has been stated about why it has been done. What was the intention? Who else? So there nothing. Only one statement has been made that these three persons have put her ablaze. Now, cross-examination part, Lordship will find. I first saw the victim at about 10:20 a.m. on 18/8/14. Victim was found on hospital bed. At the time, the victim was found talking with other person. At the time of recording dying declaration, the hospital staffs and 3 witnesses were present. I questioned the victim. I did not interfere her while she was telling the facts, as the victim could not move her hand. So I held her to put thumb impression on the declaration. I did not sign after endorsing the thumb impression. That is important, Lordship. I did not sign after endorsing the thumb impression. That Lordship may kindly note it. I did not sign after endorsing the thumb impression. I recorded the dying declaration immediately after admitting the patient in the hospital. Due to critical condition of patient, I referred her to GMCH. It is not a fact that victim was not in a position to give statement when she was brought to hospital. She was not in conscious state and she was not in conscious state. It is not a fact that I did not obtain thumb impression of the victim. It is not a fact that the victim did not mention the name of any person in her statement. Now, PW 5, your lordship, page 20. He is Ratish Sarkar. He is an independent witness here, so Ratish Sarkar. So he is a neighbor and like who was present and while the body was taken out from the pond. I know complainant Sanjay Pandit. I also know the accused persons. The occurrence took place 3 years ago around 8 a.m. On the day of the occurrence, when I was getting ready to walk, I heard shouting of Mohan Biswas saying that one person had fallen down in the pond. I arrived at the bank of the pond, but in the meantime, Nitendra Bhomik and Biren Hira lifted the woman from the pond. The woman requested to throw her in water again. This is important, Lordship. Lordship may kindly note down that the witnesses who have been declared hostile, as well as this independent witness, all have stated that the woman requested to throw her again in water. Hearing her voice, I recognized her as Piyush's wife. Later, the woman was taken to the hospital, and I saw burn injury on her person. Later, she died. So, Lordship, in his statement, he has not stated that woman has stated before the other people that these three accused have actually put her ablaze by putting kerosene oil on the body, on her. So that hasn't been stated by him. He hasn't stated anything about this, about naming of these three accused persons. Then cross-examination part, Lordship. The woman was not in a state of speaking. This is also very important because dying declaration was taken and doctor in fact certified that she was in a position to speak. But as far as this person is concerned, this witness is concerned, he specifically stated that woman was not in a state of speaking. She has just said once to throw her into water again. I saw black mark in her face. At the time, her husband was not at home. I cannot say when her husband went out before the occurrence. I do not know about the relationship between the husband and wife. I had not witnessed how did she catch fire. So he is also not an eyewitness. There was no eyewitness, in fact, Lordship. The whole prosecution case is on the basis of circumstantial evidence and dying declaration. So he's not an eyewitness, Lordship. He hasn't seen anything. Only after the victim was, at that point of time, the victim was alive from the pond, taken out from the pond, he reached there. Now, Lordship, PW6 is also an independent witness. His evidence is at page 22. His name is Vikas Sarkar. I know the complainant as well as the accused. The occurrence took place about 2 years ago, around 8:09 a.m. On the day of the occurrence, accused Mohan Biswas shouted, saying that someone had fallen down in the pond. When I rushed to the bank of the pond, I saw a woman lying in the pond. Then Nitendra and Biren Hira lifted the woman. She was not in a recognizable state. She was burnt. The woman said once, "Throw me in water again." So this statement, unlike the other PW5 statement tallies, there is no contradiction in that. As far as throw me in water again. Then I recognized her as Piyush's wife. Later, she was taken home.
The woman died. Later, I heard that woman told the accused person had set her on fire. This is a hearsay that he heard later on that she stated that like this accused person has set her on fire. In the cross-examination part, Lord said, I had not seen Ruby's husband Pizus at the time of occurrence. Pizus had gone out from house about half an hour before the occurrence took place. I do not know about the relationship between the spouses. They had 2 children. I did not see children at the time of occurrence. The woman was in an unconscious state when she was lifted from the water. So this is also Lord said she was in an unconscious state. So she was not in a state of actually speaking too many words or too many sentences. She was in an unconscious state. It is not a fact that the woman had not said anything and that she was not in a state of speaking. It is not a fact that Ruby had quarreled with her husband and she herself set fire on her. Now PW7 here also. PW7 is the police constable who was there at the point of dying declaration here also. His name is Ajit Burman. I know the complainant since after the case. I do not know the accused persons. On 18/8/2014, when I was working in Jugijan BP, information was received that a woman by name Ruby Pandit was taken to Jugijan Hospital for sustaining burn injury. I, along with the investigating officer, Nipen Soikia, went to Jugijan Hospital. I saw the woman there. The doctor recorded a statement of the injured woman in front of me. I was present. She said the name of accused Moni Mazumdar and 2 other names of the accused persons. He did not name Syamoli as such. He said that the accused Moni Mazumdar and 2 other persons. She said that they set her on fire. After recording the statement, dying declaration, doctor took my signature. Exhibit 4 is the dying declaration. Exhibit 4(2) is my signature therein. Then the cross-examination part here, Lord said that we'll find the villagers took the injured to the hospital. Nipen Sakia and I went to the hospital. The injured was lying on bed. She had burn injury on her person. I saw burn injury on her face. I saw public. The woman was in a speechless state. Lordship may kindly note down. The woman was in a speechless state. I did not understand what she had said. It is very important, your Lordship. He is supposed to be there. He was present when the dying declaration was taken. And he is stating that I did not understand what she had said. I did not see whether her husband was present or not. This is also important because later on the husband states that he was also present. That I'll come later on, your Lordship. But husband says that he was also there. But he says that I did not see whether her husband was present or not. I do not know whether she had mentioned the name of her husband or not. I put my signature when a doctor asked me to do so. I do not know whether the injured had put her signature on the dying declaration or not. This is also important, your Lordship, that I do not know whether the injured put her signature on the dying declaration or not. He is supposed to be an eyewitness and he was present when the dying declaration was taken. But in his cross-examination, he has specifically stated that I do not know whether the injured put her signature on the dying declaration or not. That may be kindly noted, your Lordship. Then Lordship, PW8 is at page 26. he is the husband of the victim, Sri Pijus Pandit. Complainant Sujay Pandit is my younger brother. This is Ruby Pandit was my wife. I know the accused persons. The occurrence took place around 8:30 a.m. on 18/8/2014. I went out for my workplace in the morning after taking meal. Then I got the information that my wife's condition was critical and I had to go home. I came home and saw burn injury on her person. Her whole body was burnt. Our co-villagers came and took her to Jugishan Hospital. Police was present in the hospital. When Ruby was asked, she told that at the time of occurrence, Syamali was stealing egg, and when she was caught, the accused persons came and set my wife on fire by pouring kerosene oil inside our house. And the accused said, if you want to save yourself, jump into the pond. The doctor wrote the said statement and took my signature. So Lordship, two things comes out from this. First thing is that like when he came back home, his wife said nothing to him about these accused persons. He specifically stated that I came home and saw burn injury on her person. Her whole body was burned. Four villagers came and took her to Jugishan Hospital. So at that point of time, when the husband came, that victim did not say anything about the accused persons or how the incident took place. Nothing has been stated at the place of occurrence. Now, later on, what he states is that this is the first thing is that the victim did not say anything about these three accused persons. The second thing, as Lordship will find that what he has stated is that when Ruby was asked, she told that at the time of occurrence, Syamali was stealing egg. And when she was caught, the accused persons came and set my wife on fire by pouring kerosene oil inside our house. And the accused said, if you want to save yourself, jump into the pond. The doctor wrote the said statement and took my signature. This was not a dying declaration, Lordship. But I have already read out. I'll come to that exhibit, Lordship, that is exhibit 4, where dying declaration, the content is there. This part it's not there in the dying declaration. This is a story that they have made out later on. Syamali was stealing egg. She was caught, the accused. These things were not there in the dying declaration. Now, Lordship, the cross-examination part. My wife died on the way to Guwahati. At the time of occurrence, my elder son was 8 years old, and my younger son was 8 years old. At the time of occurrence, they were at my younger brother's house. I received the information at 9 o'clock. My helper and I came to my house riding a motorcycle. I found my wife in my house itself. At that time, police also came. The VDP secretary also came. Around 50 people gathered. There were burn injuries on her entire person. She was unable to move. Sanjay Pandit, Sukharjan Pandit, and I took my wife to the hospital. Now, my wife and I did not state before police that when Syamali was going after taking egg, my wife had caught her. It is not a fact that my wife did not give statement in front of me. So the first statement, your Lordship may note, my wife and I did not state before the police that when Syamali was going after taking egg, my wife had caught her. So they have denied, he has denied that he has stated anything to the police about this, as far as the story of laying of egg by the hand and catching catching Syamali is concerned. PW 9, you'll also will find at page 28. He is a village VDP. His name is Madhusudan Chakrabarti. I know the complainant as well as the accused. I knew this is Ruby Pandit too. The occurrence took place on one day in the month of August 2014. It was around 8:30 a.m. I was in the shop. At a time, one nephew of Pijus came and informed me that Ruby Pandit caught fire. I went and picked up Ruby from water and laid her on a banana leaf. This is a new story, Lord. So this is a new story because in earlier versions, in the earlier versions of the witnesses, it was two other persons called Nilendra and Nitendra and Viren Hira. They took her out from the pond. But now he is stating that I went and picked up Ruby from water and laid her on a banana leaf. This is something new with what he has stated. Police was informed. We took her to hospital when police asked to do so. We met police on the road. She died on her way to Guwahati from Jugijan. When the doctor of Jugijan Hospital asked, Ruby had said that the three accused persons set her on fire. But this person was not a signatory to the dying declaration, though he claims that he was there, but he didn't sign the dying declaration. But he states that these accused persons, that the victim has stated that accused persons have set her on the victim on fire. The cross-examination part, Lordship will find, I was the VDP secretary at the time of occurrence. When I went, Ruby was in a state of speaking. Her face was not completely burnt. When Ruby was at home, I had not asked her. I cannot say the name of the doctor. It is not a fact that Ruby did not give any statement in the hospital, that she did not say anything, that she was not in a state to speak anything. It is not a fact that I did not state before the police that Ruby had told the names of the accused persons in the hospital. It is not a fact that I have adduced false evidence today on being tutored by Pijus. Now, PW 10, Lordship. PW 10 is one M. Gita Devi. She was a nurse when the dying, she was present when the dying declaration was taken by the doctor. I know complainant Sujay Pandit from the day of the occurrence. I do not know the accused persons. On 18/8/14, while I was working as a GNM nurse at Jugijan PHC, a woman with burn injury was taken to the hospital, which resulted in much activity in the hospital. Dr. K.J. Chaudhary was on duty, so I informed him. The name of the woman was Ruby Pandit. Police came to the hospital. As the condition of the patient was critical, so Chaudhary sir referred her to Guwahati. Chaudhary sir recorded a statement of the woman. I was present there. My signature was taken as a witness of the statement. Exhibit 4 is the statement and Exhibit 4.4 is my signature therein as a witness. When the statement was taken, Ruby Pandit was in a state of speaking. She stated that 2-3 persons entered in her house and set her on fire by pouring kerosene. This is very important, girls. What she states is that she stated that 2-3 persons entered in her house and set her on fire by pouring kerosene oil. She did not say any names. She did not take any names, Lord. Now, how these names came later on in the dying declaration, that I do not know. But she was there before while the dying declaration was taken. She was present, and she states very specifically that the victim, she means the victim. Victim stated that 2-3 persons entered in her house and set her on fire by pouring kerosene oil. So she was an independent witness. She was the nurse while the dying declaration was taken. And she has specifically stated that the victim stated that 2-3 persons entered in her house and set her on fire by pouring kerosene oil, and no name of any of these accused have been taken. It is the version of the person who was a witness there while the dying declaration was taken. And Lordship, one thing I have noted down, I would have liked to point it out later on. But since my learned friend has already he's pointing out to me, I'll just point out before your Lordship also. Lordship, that dying declaration, Lordship will find at page 85. Kindly have a look on that, Lordship, because only for one thing, Lordship, is that just to point out your vehicle, because this 3 witnesses were, while the dying declaration was taken, the doctor stated that in presence of 3 persons. So 3 persons, Lordship, one is Ajit Burman, one is Sikha Pandit, and one is Piyush Pandit. But this lady was not, she hasn't signed the dying declaration.
Who did not sign?
So this lady, this nurse, Lordship, so her name was not there, but Lordship will find that signature is there. At page 86, signature is there. So page 86, the signature is there, but her name is not there on page 85.
It is Gita Devi.
Gita Devi. So Gita Devi's name is not there. That while taking that is what it is stated. I'll come to that a little bit later on here also. But her signature is there, but like her name was not there. But anyway, Lordship, we'll take. I'll take your Lordship again to page 31 only. Then Lordship,
Just 1 minute.
yes, Coach.
name is there.
Page 31.
Page 86.
And her page 86 signature is there, Lordship. Signed SD M Gita Devi. Yes, but her name is not there on page 85, your Lordship. There's 3 persons were named there. But there is some kind of discrepancies, Lordship. That's why this thing. And she specifically states that she was present. So she states that she was present here also. Now, she specifically states that she was present there. While
That way she is correct.
I'll
There she put her signature.
I'll take it as she is there. And that's why I'm saying, Lordship, she has specifically stated she was there, and she has specifically stated that victim stated that 2-3 persons entered in her house without naming anybody.
We'll have to see the original.
Lordship, that has to be seen. Lordship, that has to be seen. But my humble submission and argument will be that the victim never stated about the person's name, because she was present there, and she has specifically stated that I was present while the dying declaration was taken, and the victim stated that 2-3 persons entered in her house. without naming anybody, Your Lordship. Now, Lordship, will come to the cross-examination part. Her face was not burnt. The remaining part of her person was burnt. The injured was from Bengali community. When Dr. Chaudhary asked, she was saying her utterances were ineligible or intelligible. I cannot say who did write her statement. This is very important, Your Lordship. I cannot say who did write her statement. I put my signature after writing. I have forgotten who did tell me to put my signature. I did not notice who did take her thumb impression. So it's totally contradictory to the statement.
Last line. Last line.
Last lines he says that it is not a fact that the statement was not written as per Ruby's version. So it's very contradictory.
What does it mean?
It means that she states that
It means that it was recorded as per the Ruby's person.
but thing is that what she is stating in the cross-examination is that I cannot say who did write her statement. I put my signature after writing. I have forgotten who did tell me to put my signature. I did not notice who did take her thumb impression. So what comes out from there, it's a thing to be interpreted, you know, and creates any kind of interpretation significantly has some kind of doubts also in this kind of factual situations. So it creates a doubt, you know, so whether the lying declaration was properly taken.
Once it creates a doubt, it should go in your favor.
So Lordship, Lordship, somebody has to be punished. Somebody has to be put inside the bar for life. So Lordship has to consider those things.
But dying declaration also, we cannot just brush aside.
No, Lordship, no, I'm not saying that, Lordship. I'll come into this, Lordship, because this case, the whole case is based on the dying declaration part and the circumstantial evidence. These two things. Now, as far as Lordship, this dying declaration part is concerned, so like Lordship has already seen it, like how it has been done. If it is done, also how it has been done. Whether that can be trustworthy or whether that can be cogent evidence, reliable evidence under Section 32 of the Evidence Act, whether that can be relied on, that Lordship has to examine. Now, Lordship, page 32. Page 32 is the evidence of Nipen Saikia. Nipen Saikia is the investigating officer. Lordship. On 18/8/2014, I was working as in charge at Jugijan Police Outpost, PP, Jugijan PP. On that day, informant Sanjay Pandit lodged an ejahat against the accused Mohan Biswas, Chamili Biswas, and Mani Mazumdar about burning Ruby Pandit, the wife of his brother, by accused. After receiving the FIR, I made a GD entry by Jugijan PP entry, GD entry number 309, dated 18/8/2014 at 4 p.m. and forwarded to OC Hosai to register the case. Accordingly, the said case was registered as Hosai PS case number 400 of public 14, and I was endorsed to investigate the case. I recorded the statement of the informant. ASI Subarna Kumar Das, before filing the FIR, he made another GD entry 304 dated 18/8/14 after getting verbal information regarding the occurrence, and he visited the place of occurrence and sent the victim to Jugijan PAC, and he Also recorded the dying declaration of the victim by doctor and sent the victim to GMCH for better treatment. He also recorded the statement of few witnesses and he brought the accused person to Hosai PS. I interrogated the accused Shamali Biswas, Mohan Biswas and Champa Majumdar and recorded their statement. Accused Shamali Biswas has confessed the guilty during the time of examination. I forwarded all the accused to the jail custody. I collect the dying declaration of the victim. On 19/8/14, I got the information about the death of victim Ruby Pandit at Guwahati. I recorded the statement of witnesses, namely Pijus Pandit, Srimati Sikha Pandit, Ajit Burban, GNM Gita Devi, who were present at the time of dying declaration of the victim. I collected the copy of dying declaration as well as PM report. After completion of investigation, I filed a charge sheet against the accused persons under section 448, 302, 34 IPC. Exhibit 5 is the charge sheet and Exhibit 5(1) is my signature. Exhibit 6 is the CD. Exhibit 6(1) is the statement, 161 statement of the accused Shamali Biswas. And Exhibit 6(2) is my signature. Exhibit 6(3) is the 161 statement of Srimati Champa Majumdar, alias Mani. And Exhibit 6(4) is my signature. I also collected the inquest report from GMCH Guwahati. In a cross-examination part, Your Lordship, the day of occurrence is on 18/8/14. On that day, I was busy with another case. For that reason, ASI Subarna Das went to the place of occurrence for doing the investigation. At a time, I was not present at PS. GD entry was made by GD entry number 304, dated 18/8/14, by ASI Subarna Das. He visited the place of occurrence, took the injured person to Jugijan Hospital, and the victim was referred to GMCH Guwahati for better treatment, and the dying declaration of the victim, etc., had been done in Jugijan Hospital by ASI Subarna Das. I did not visit the place of occurrence. After referring the victim to Guwahati, the FIR was lodged at 5 p.m. on 18/8/14. The statement of the informant Sanjay was recorded by me. Informant is the brother of the husband of the deceased. At the time of recording the dying declaration, I was not present there. On 2/10/14, I have recorded the statement of Pijus Pandit, the husband of the deceased. I cannot say when the husband of the deceased Pijus Pandit went out from his house. I have not written anything regarding the dispute between the husband and wife. I have submitted the charge sheet based on the investigation of ASI Subarna Das and partly of my own. The burn was committed inside the house of the husband Pijus Pandit. At a time of committing burning, husband was outside from the house and also children were not in the house somewhere else. It is not a fact that I have submitted a charge sheet on mere suspicion. So he was actually lots of like he came to the scene a little bit later on. So most of the investigation, initial investigation was done by that another police officer called Subarna Kumar Das. So Subarna Kumar Das, Lordship, PW12, his evidence is at page 34. On 18/8/2014, I was working as ASI at Jugijan PP. On that day at 9:30 a.m., one VDP secretary of Radhanagar, Sri Madhu Chakraborty, informed over the phone that a lady was set fire by two women by pouring kerosene, due to which she was totally burned and in critical condition. Accordingly, I made a GD entry by Jugijan PP GD entry number 304 dated 18/8/2014 and informed the matter to the higher officer and I proceeded to the place of occurrence along with the staff. I proceeded to the place of occurrence as the in charge of Jugijan PP, went to the SP as the in charge of Jugijan PP went to the SP office Nagaon for official purpose on that day. On that day, at about 10 a.m., I arrived at the place of occurrence and found that the victim Ruby Pandit was in critical condition, and I arranged to send the victim to Jugijan PSC for her treatment. I also prayed the doctor of Jugijan PSC to record the dying declaration of the victim, as the victim was in a very critical condition. So here he states that he has gone to the place of occurrence here also. Thereafter, I again, because later on he states later on in his cross-examination, he states that he has met the victim on the road in auto rickshaw. So the going to the place of occurrence and all, that is not there. So whatever he has found out, stating that place of occurrence, I found this, I have found that, that is little bit unreliable, because he himself states later on that he met the victim on the road in an auto rickshaw later on.
How long will take, Kalita?
Actually, I'll take some time also, because there are other PWs, then I'll have to refer to the judgment also. There are certain case laws are there on dying declaration. There are a lot of cases which have been referred. There are certain cases I'll have to point out here also. Light agriculture like that. Agriculture like that. I will take at least 1.5 hours.
See, the issue is this, we have had two appeals. Yours left.
Yes, sir.
Other side has completed also.
Yes. Because
We are not sure when we are going to sit again.
Lordship, I understand. Because Lordship, earlier I was not handed over the, I was
No,
not
I
given the.
understand
Yes,
that part.
yes.
Only thing is, should we keep it part heard?
I think
We are
Lordship,
thinking about the
yes.
appellants, we are thinking about the appellants.
Lordship
If
was
you
already.
keep it part heard,
It was already kept as a part hard. But now if it is not continued tomorrow or Monday, if it is not continued, then it will be difficult on our part, because the most valuable time of the court and most valuable time of the lawyers also will be.
no, the issue is, now we don't know when we are going to sit. From Monday, I may not be around. My brother will be here. After I come back, my brother will be going out. So we are thinking of the appellants, the interest of the appellant.
Lordship, rightly Lordship.
It's up to you.
Keep it part
Lordship has to keep it parted, because Lordship, I mean, they have already finished. Prosecution side also already, they have probably given a written argument also.
So that's
But
why,
if my party is there, Lordship, another 1.5 hour will be required any day, Lordship. Whenever both your Lordships are there, it can be considered, we can finish it off, because there is no other way, Lordship.
If it is possible tomorrow, maybe please.
tomorrow will be.
Impossible.
Bench available, no bench possible.
Special bench. Yeah, we'll have to constitute another bench. It will be difficult. But Mr. You are in the first case.
Yes, I am in the first. I will have it.
Responsible for the appellant and criminal accused, but to accept Also heard Mr. A. Tiwari, that amicus curiae in criminal appeal within bracket J, number 15 of the. As per and Mr. K. Kalitala, amicus curiae in criminal appeal.
16 of 2020.
16 of the- Also heard Mr. P. Raja, uh, 13 part is forfeit a hearing. After
As and when the bench can be.
after which if
Lordship.
if you want it released, we can release it now. But
My lordship, lordship may not release this because already.
In a part of the legislation.
second,
My lord, before rising, my lord, I have one matter, my lord. I was ready to argue for the public prosecutor also because due to time constraint, my lord, it cannot be taken up. So there is a stay element is there, my lord. The interim order of stay maybe kindly be extended until further order. my lord.
heard Mr. Z. Kamal,
Mr. Das.
state counsel for the absent.
Also, Mr. Didas was present, my lord. Didas, he was
Heard
sitting.
Mr. Didas.
Yes, my lord.
Representative PP Assam.
Yes, my lord.
PP Assam. Due to paucity of time, this case could not be taken up today.
Interim order passed earlier.
This is the matter after.
My lord, whenever your lordship sits, my lord.
No,
As your lordship please, I have got no problem.
not the part. But
Yes, it's not a part of matter, my lord.
after a week.
After 2 weeks, my lord, I bet.
to-
In the meantime, the interim order passed
to
earlier
order passed earlier to come.
shall continue, my lord.
Next. return.
March over. March over.